Yes. Lordship, one case is listed at item number 6 of today. In this case, I have filed 2 petitions, Lordship, one I and one additional affidavit. But that is not tagged to it. The registry may be directed to tag with. Registry may be directed to tag with the petitions and may be taken up after all the admissions.
Lordship, I beg to mention hearing item number 18, Lordship.
18?
Lordship. Lordship, in this matter, Lordship, I am here to receive instruction, Lordship, if a week's time may be granted, Lordship, so that I will take an instruction from the.
It will be the last chance because they have seen adjournment for more than 10 times.
You've taken a lot of adjournments.
Lordship, since I'm here to receive instruction from the.
What's the matter about?
It's regarding that of 2. In fact, the main matter here before the High Court is that they have not sought prosecution sanction under the Armed Forces Act. This is it. case before the court.
We have it next week.
No, Lord.
Lordship.
That's the last chance question.
Lord.
And Lordship, there is an interim order also.
Interim order.
Yes, yes.
Mr. V. Jimomi, the learned counsel appearing on behalf of the state of Nagaland, request for a accommodation today. Mr. Yangavati, the learned counsel appearing on behalf of the petitioner, submits that on earlier occasions, various adjournments have been taken by the state of Nagaland. For the interest of justice, the matter is fixed again on, directed to be fixed again on 26/2024. This court makes it clear that the state shall not, makes it clear that no further accommodation shall be granted to the state on the next date.
Lordship.
So the interim order passed earlier shall continue till the next date.
Much obliged.
May I please, Your Lordship? I beg to mention item number 25.
Huh?
I beg to mention item number 25, my lord.
25.
25, my lord.
What?
The man counsel appearing for respondent number, private respondent 5 to 87. He could in turn up due to his ill health.
No, that means the entire matter will go. I can't segregate one matter.
My lord,
You make your mention when the matter reaches, we'll see when.
much good.
For motion, item number 1.
Yes, madam, what are you challenging?
Your Lordship, the present criminal revision petition is being preferred against the interim judgment order dated 27/2/2024, which was passed by the Family Court Dimapur. Lordship, the gist of the case in a nutshell is that both the petitioner and the respondent, they were living together as husband and wife since 2015. And at present, they have been separated and the respondent has remarried. The petitioner, prior to the marriage, was working as an assistant stateroom stewardess in Carnival, that is an international cruise line company based in Miami, Florida, USA. And she was drawing a monthly salary of rupees 1,80,000, but left her job on the behest of the respondent after marriage, while the respondent is serving as a soil survey officer under the Department of Soil and Water Conservation, Government of Nagaland. By stating that the petitioner is presently unemployed and against the backdrop, an application under section 125 CRPC was filed before the Family Court, Dimapur. In the meantime, the respondent filed an IA for the dismissal of the case on the ground that the maintenance was not maintainable, as this customary court had already passed the verdict. While the matter was thus situated, the Family Court, by order dated 27/2/2024, dismissed the maintenance case. Your Lordship, in the light of this, I would like to draw your attention to Annexure 1, that is the order dated 27/2/2024 at page number 32, para 2.
We admit this. Madam, we admit
Admit,
this revision application.
obliged.
Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. The instant application is an application under section 397 and 401 of the Code of Criminal Procedure 1973, read with section 19(4) of the Family Courts Act in 1984. The instant application arises out of an order dated 27/2/2024, whereby the application filed under section 125. 125, no?
Yes, Your Lordship.
125 of the CRPC was held to be not maintainable, thereby allowing the have been held to be not maintainable, on the ground. Been held to be not maintainable. Full stop. In as much as the dispute between the petitioner and the respondent have already been settled by the customary court. Full stop. The instant revision application raises a very important question. As regards the applicability of section 125 CRPC vis-a-vis any settlement order given by the passed by the Dobashi court.
Dubai GB customary code.
Hmm?
GB customary code.
GB customary court. Isn't it the Dobashi court? No.
GB customary code. Dubai, not Dubai, it's GB customary code.
No, it is mentioned passed by the Dobashi customary court. Kifri. Isn't that the order? 15/11/2018. Kindly see page 33.
Your Honor, that was the order passed by the Honorable Family Judge, but as per the notice that we received from the customary court was from the GB's customary court, Kifri town. GB, not DB.
DB customary court.
GB, Gaumboras. Gaubura.
But everywhere it has been mentioned as DB.
There in this, in the settlement order, the settlement order also is, it's written GB's customary court, Kifri town.
But
Not
here the
DB.
order says about DB everywhere. Here the petitioner did not get the benefit in view of the order dated 15/11/2018.
Yes, Lordship,
Isn't
but
it?
that, I think there was a mistake from the order passed by the family judge, but as per the documents that we have, the order was passed, the settlement order was passed by the GB customary court. Your Lord, since the settlement order was never served to me, I just have
Okay.
only the notice, I have the summon and the notice.
But the court holds it that you have enjoyed the benefits.
Lordship, with regard to,
It's okay. Let's put it as per what the court says. As per the Dobashi court, important question of law arises as regards the applicability of a section 125 proceeding vis-a-vis an order passed by the Dobashi customary court, Kifri. Under such circumstances, this court admits the instant petition. Issue notice to the respondent. Steps be taken by way of registered as well as usual within 3 days. You return the instant matter be listed again on 22nd of July.
From the supplementary cost list for motion, item number 19.
Yes, what offense?
May I please, Lordship,
Yeah, what
the
offense?
petitioner is one of the accused.
You are inside or outside? You are inside or outside?
Inside, my lord. I'm
How-
still in
how
jail
long?
now. My previous bail application was
Is
rejected.
it NDPS?
Yes, my lord, under 21C.
Call for the case, there. Call for the case, there. When? Is it a Still under investigation.
Yes, my lord.
Charge sheet not submitted.
I think so, my lord.
Call for a case. There, beginning by we do it in how much time?
After a week.
Let's have it on 18th of June. Would it be possible? Or should we fix it on
28th. Yeah.
26, 2020?
For admission, item number 2. Maybe, Your Lordship. Lordship, in the last instance, Your Lordship, the action was given to the government, Your Lordship.
What?
The action was given to the government, Your Lordship, to produce the minutes of the meeting, Your Lordship. Maybe, Lordship. My Lord, I have, as directed by the Honorable Court, I have already informed the department to furnish the record, but I have not received. However, my Lord, during the pendency of this writ petition, my Lord, the petitioner has completed 30 years. So as per OM 2015,
You are on,
eligible, my Lordship, will file a reply, Your Lordship.
You are getting the scale of pay
Yes, Your Lordship.
and you have completed 30 years?
Yes, Your Lordship. As
So
of
you
last
need
year,
to be considered.
Lordship. Yes.
We dispose it of on that
Yes,
basis.
my Lord. Yes.
Or Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. So-and-so appearing on behalf of the respondent state. Why there are so many private respondents?
Lordship, here initially, Your Lordship, the juniors, Your Lordship, they were appointed before me, Your Lordship. Regularized, Your Lordship.
Anyways,
No.
you are okay with it?
Yes, Your
You are
Lordship.
not seeing any
Lordship. As per
challenge,
2015.
senior.
Yes, sir.
The petitioner herein was appointed as a work charge handyman against a sanctioned existing post caused by Sri L. Tia Jamil against a vacancy caused by Sri L. Tia Jamil, work charge handyman, who resigned from service in a pay scale. Full stop. Thereupon, the petitioner continued to render his service without any break. Mr. Counsel,
Lordship.
no break,
No break, Your Lordship.
without any break. Full stop. Where is that notification? Office memorandum of 2015.
Annexure 1 in
You have not
affidavit in Lordship, affidavit in reply, Your Lordship.
Huh?
Affidavit in reply, Your Lordship. Annexure 1, Your Lordship. Page number 5, Your Lordship.
It is the case of the petitioner that the private respondents herein were junior to the petitioner,
Yes, Your Lordship.
but they were regularized. However, depriving the petitioner of the benefits of regularization. First, Mr. So-and-so, the learned counsel appearing on behalf of the respondent, state submits that in the meantime, The petitioner has already completed 30 years of service in view of the fact that he was appointed on 16th of May 1994.
Yes, Lordship.
That too on a scale of pay. It has been brought to the attention of this court that on the basis of clause 1 Roman 2 of the Roman 2, na?
Roman 1, Your Honor.
No, not 1. 1 is for those who have completed 30 years. 1 Roman 2. Where is that?
Roman 1, Your
Office
Lordship.
memorandum.
Roman 1, Your Lordship. I've completed 30 years, Your Lordship.
Where is the office memorandum?
Affidavit in reply, Your Lordship.
I'm not getting the affidavit in it.
Your Lordship, we have filed it.
Give it to me. Yes, Roman 2. Yes, in respect to works,
Lordship.
it has been duly submitted that in terms with the office memorandum dated 17/3/2015 and more particularly clause 1 bracket Roman 1 bracket Roman 2, those work charge and casual employees in the scale of pay who would be completing, who have completed or would complete 30 years of continuous service after 1/1/2015, their cases for regularization would be taken up subsequently in 2 batches on the 1st of July and 1st of January every year. Full stop. In view of the said extent policy, which still holds the field, the petitioner herein is entitled to be considered for regularization in terms with clause 1 Roman 2 of the office memorandum dated 17/3/2015. As he had completed 30 years of service as on 15th of May 2024.
Yes.
Under such circumstances, taking into account the prayer which have been made in the instant proceedings and the specific submission made by the counsel appearing on behalf of the petitioner, that the petitioner has no quarrel with the appointment and regularization of the private respondents if the petitioner's case is considered in terms with the office memorandum. This court directs the respondent authorities to consider the case of the petitioner for regularization in terms with clause 1 Roman 2 of the office memorandum dated so and so 17/3/2015. The said exercise be completed within a period of 4 months.
4 months.
From the date of a certified copy of this order is served upon whom?
Respond number 223.
Respond number?
Respond number 1, 2, and 3.
Why? So many people
Yes,
need.
because
Only one certified copy is to be given one. The others can share it. Where first you are not regularizing him and you want so much
Three,
of money
three,
to be
my lord.
spent by him. Respondent number 2.
3, my lord.
3.
Yes.
Respondent number 3. Full stop. This court further directs that upon submission of the certified copy of the instant order to the respondent number 3, the respondent number 2 also shall do the needful so that the above order, the order passed herein is duly complied.
Lord. Much obliged.
Then you'll rope in both.
For admission, item number 3.
May I please, Your Lordship? Your Lordship, here the petitioner's
are aggrieved by the order passed by the Deputy Commissioner. And he has been impleaded as respondent number 3. Now here, the Lordship, the Office of the Deputy Commissioner, while handling this matter, has acted as a court, and the respondent number 3, that is Deputy Commissioner, has exercised his judicial duty, Your Lordship. So my humble submission is that in the Supreme Court in Savita Devi's case, here also the Supreme Court has disapproved of impleading the district court and other judicial officers as respondents. So my humble submission is that, Your Lordship, if respondent number 3 can be deleted,
Who is respondent number 3?
the Deputy Commissioner, Your Lordship.
Why?
Your Lordship, here he has exercised, he passed the order that is being impugned here in his
It is a judicial order,
Yes, Your Lordship.
and as such, he should not be made a
Yes, Your
party.
Lordship.
Okay, we'll consider that. First, let us dispose of the matter. Tell me, who is the counsel for the petitioner? Yes, argue. Don't
Yes,
think about him. Don't look at him. Argue.
Lordship. Lordship, this is a dispute over the illegal sale of land between the village of the petitioner and the village of the respondent. Lordship, here, sometime in the year 1998, the village resolved not to sell land, not to sell village land to any neighboring villages or any other individuals. Now, the same was adopted by the Petitioner Citizen Unit in the year 1999. Now, in 2000, the petitioner number 3 sold a plot of land, a reserved land, to the respondent number 1. Now, when the village of the petitioner learned that the plot of land has been sold to the respondent village, they objected. Because as per the Nagaland Village Council Act, Section 15G, no land can be sold without the consent of the village council. So therefore, the village of the petitioner, they refunded back the amount of rupees 2,000 to the respondent number 1 for the illegal sale that has been made between the two individuals. Now, the respondent village, not willing to part with the plot of land that they have already bought, has been, creating an issue.
So
So,
there must have been a dispute.
yes, Lordship.
Then you have approached the DC.
Lordship,
The DC must have referred to it to the Dobasi court.
we first, the matter was first adjudicated by the Dikir Tribal Council, which is the apex body of the two parties. So the Dikir Tribal Council has passed an order directing the petitioner village to pay 25,000 for the plot of land as per the existing market value, and another 25,000 for the firewood that was taken away by the petitioner, cut down by the respondent. Now, aggrieved by this, the respondent village appealed before the Topashi court. Now, Topashi court has again passed an order in favor of the respondent village. Therefore, Lordship, the petitioner again appealed before the Deputy Commissioner. Now, the Deputy Commissioner, Lordship, in total violation of the statutory act, that is Section 15G of the Nagaland Village Council.
What does the Deputy Commissioner do? Let us see the Deputy Commissioner's order.
Lordship, may kindly come to
Page 86.
the statement.
Hey, give me the rules of administration of justice. So the deputy commissioner decided you had a selling village.
Yes, Lord.
So decided in favor of the petitioner number 3,
Okay.
in favor of the petitioner number 3.
In favor of the respondent number 1.
No, in favor of the petitioner number 3 also. Because the petitioner number 3 have all along maintained that I didn't know that there was a resolution.
Yes, Lord. In other way around, we can take it this way also.
Yes. So here a person who duly admits that I didn't know I have a legal right to sell it, then also that person is here aggrieved. How can he be aggrieved?
Lordship, because initially.
Initially what? He also went before the deputy commissioner and said the same thing.
Lordship, before the whole thing happened, initially he was not aware of this of such resolution. Therefore, he sold away the land. Now, on learning about this sale being illegal, now he also wanted to take back the land by making a payment of the amount that has been made to him, made to the respondent. Lordship, in that case.
When did you sell it?
In the year 2000.
And when was it returned to be returned?
Lordship.
When was it to be returned?
Lordship, somewhere in the year 2018, 17. Like that.
18. So 18 years, the value of the land have gone up. You are willing to pay the 25,000?
Lordship, we have already paid.
The 25,000.
We have already paid 50,000. We have deposited into the hand of the TQ Tribal Council. Now it is the contention of the respondent that we have not received. We have not, but it is learned from some sources that they have.
How did you pay?
Cash, Lordship. We deposited the amount to the.
Did you get a receipt?
Lordship, we do not have such.
Then how do you know?
Lordship, therefore, Lordship, the TQ Tribal Council, this honorable court has actually directed to implement the TQ Tribal Council. Notice has been completed, but so far they have not appeared.
What is the tribal council going to do here?
Since the payment was
Did you take a stand out there in the appellate that we have already paid the 50,000? Did you take a stand there? Or did you do it only after that order is being passed on 18th of December 2019? Yes, where is that? Blue. See, you must be here, that blue one. Hmm? Yes, madam. I have therefore not asked you to leave. Tell me, what is the procedure? You are the government, you know. The fact is simple.
Yes, Your Lordship.
Here is a case where the petitioner number 3 tells very much before all authorities that look here, I have a right over this land, me and my uncle. This land, I sold it to the respondent number 1 on the ground that this is there. He has paid me, and on the basis of an agreement for sale or sale agreement, I have already sold. He said that he did not know about the resolution. Now there is the court, the deputy commissioner category holds that it is not, no, it cannot be so. But the deputy commissioner also comes up and say that these are two closely knit villages, by which one village there are buying and selling which is seen. So under such circumstances, honor the sale.
Yes, Your Lordship.
What is wrong?
Well, Your Lordship, there was no illegality committed by the DC while passing this order.
No illegal,
Yes, Your Lordship.
right?
Because the sale deed was executed. After 10 years, only the respondents, they challenged this sale deed, Your Lordship. After 10 years of enjoying the land, Your Lordship.
But tell me only one thing. Let's see section rule 31. An appeal shall lie from a decision of the Muzada Gambura Dobashi to that tribal court, which otherwise we are the deputy commissioner. A record shall be made of the matter in dispute and the decision of the village council. If necessary, the court shall examine the party, and if the decision appears to be just, shall affirm and enforce it as its own. Okay. If the court sees reasons to doubt the decision, it will try the cases de novo or refer it to the panchayat as above. Now here is a case where the court has gone against the decision of payment of 25,000 and 25,000. Isn't that the order of the Dobashi court?
Okay.
If that be so, did the DC try de novo? Had the records of the DC come?
May I please, Your Lordship? Sorry for interruption, Your Lordship. Lordship, here I'm appearing above on behalf of the counsel for the respondent number 1 and 2, Your Lordship. Ailia Matoshi, the leading counsel is from Dimapur, Lordship. Lordship, the petitioners have filed their affidavit in reply this morning only, which I have received, Your Lordship. So,
Why do you need the affidavit in reply?
they have filed it, Your Lordship.
Why is it necessary even an affidavit in opposition? It's a different thing. Here they have a good practice of filing all these things, but in respect to criminal revision, civil revisions, there's no concept of filing anything out here. You have to see on the basis of the records as to whether the records permit to so and so. Just for example, in a quashing matter, can you say anything out there by way of an affidavit that this is what it is? It has to be only seen on the basis of the quashing as to whether the right order is right or wrong. That's all. Or whether a case is made out on the basis of the FIR. It's a different thing. You have a practice of filing this and another thing. I'm not going even to consider your affidavit in opposition or his reply. Let us see on the basis of this. You don't come up with all these things. Madam, if this is the only record, have a look at it. Does it show that there is any de novo trial? It will try the case de novo. Is it anywhere shown? For the confirming, you don't require. For confirming a decision of the GB court, you don't require anything. They may confer on the basis of justice, good conscience and everything. But the moment you have a doubt over the case, can you do so? That's the only question. Does the record suggest that there is any de novo? Yes. Was there any de novo trial?
No, Lordship. No, Lordship.
Now, kindly see paragraph 7 of that order. That the fact Sri so-and-so had admitted in the presence of all concerned on this day and in this court that he was the individual seller and he has sold the land willingly to so-and-so, that neither he nor is aware of the said village resolution. Also considering the two villages have a shared history and kingship and has been practicing buying and selling of land between the citizens of each other without any issues. What is the basis on which it is being said this? What is the basis? The DC has come to this opinion. Paragraph 7. There has to be some basis, some materials or some evidence, but the records does not show any evidence.
Your Lordship, in the affidavit filed by the private respondents,
Where? No, madam, not here. Therefore, I'm saying, we are not concerned what they say, because this court cannot do a de novo trial. This court is only going to see as to whether the deputy commissioner was right in doing so or wrong. But the question is, when he doubts the decision, isn't it the manner that he has to also have a record of the proceedings? Confirming, no problem. But when he says this, kindly see paragraph 7. Is it possible? Madam Sukroy, can you just help us about this thing? I may not be much knowing about it. Kindly see paragraph 7. Okay, now kindly see this rule 31. This is the power exercise. Confirming, no problem. Okay,
yes.
now see the records here. There's nothing. How can the DC arrive at this decision without there being any evidence taken if it is a de novo trial? Nothing.
Yes, nothing. And as per his order, it seems he has tried the law.
So he said that he came over, but the
Yes,
DC cannot do that.
exactly.
For a customary court to do it, it's okay.
True,
They
your
can do
lordship.
so because there is
Yes.
nothing.
Yes,
But for a DC to do,
yes, yes,
he has to do it something.
exactly, lordship. Yes,
Otherwise, it will have nobody will know anything.
yes. It is okay.
The basic idea of 31 is
Yes.
you confirm.
No
You need
problem.
you may confirm. If it
Yes.
has been rightly done, you confirm.
Yes.
You need not go for anything.
Mhm.
But if you don't confirm or
Yes.
doubt the decision, you have to go for a de novo trial.
Exactly,
A
lordship.
de novo trial requires that you
Mm.
have to take record the evidence. Nothing is there on record.
Exactly, lordship.
You set aside this order and remand it to the deputy commissioner to decide again.
Lordship. I think- okay.
Because otherwise it will have the deputy commissioner is not the customary court.
True.
Yes,
Yes.
very less of evidence or anything. Customary court can do very many things.
Mm.
But the deputy commissioner, if he goes for a de novo trial, then he has to record something.
Exactly, lordship. Yes. Watch me.
We'll ask the deputy commissioner to decide afresh. If the deputy commissioner wants to go for de novo trial, it is required for him to record evidence. The instant application under article or section under Article 227 of the Constitution, read with Section Rule 32 of the Rules of Administration of Justice and Police in Nagaland, is filed challenging the order dated 18th of December 2019, passed by the learned Deputy Commissioner Khifri in Nagaland, whereby the order passed by the order passed dated 30/10/2018 by the District Customary Law Court, Khifri, was interfered with. Pusta. From the materials on record, it transpires. I've heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner, so-and-so appearing on behalf of the respondent number 1 and 2, and Ms. So-and-so appearing on behalf of the respondent number 3. From a perusal of the materials on record, it transpires that the petitioner number 1 herein petitioner number 3 herein had agreed to sell a plot of land to the respondent number 1 on 18th of December 2000 and thereby signed the sale agreement between the two. The demarcation of the said land after the sale was done by the uncle, one Tothong, Tothong, brackets since deceased, and the elder brother Tokhim, Tokhim, since deceased, of the petitioner number 3. Dispute arose thereupon in view of a resolution passed by the petitioner number 1 village, claiming that there was a resolution passed in the year 1998 that no person of the petitioner number 1 village would sell the land to any other, to an outsider without permission of the village council. In view of such a dispute which arose, the petitioner number 1 village approached the tribal council.
Yes, Lordship.
Tribal council. What is the full name?
Declare Tribal Council.
Huh?
Declare Tribal Council.
Give the, yeah, where do I get it?
Page 61, Lordship. And it's
Page.
Lordship, page 67.
You approached the deputy commissioner.
Lordship, prior to that, the ADC, the ADC has directed the village to amicably settle the issue
No, it's okay, but
So-
why would the ADC do unless you approach the deputy commissioner?
Lordship, because the disputes, I mean, between the village where,
So you somebody approach the deputy commissioner.
Lordship, there's nothing on record to show like that. Both the villages were summoned by the ADC and to settle the matter amicably.
At approach. The deputy commissioner,
The ADC, additional.
the deputy commissioner. Whereupon the additional deputy commissioner, Kumpro, Nagaland, directed the village council, the petitioner number 1, as well as the respondent number 2, and the petitioner number 1, as well as the, what is the spelling? M-E, Metongar Village Council, METENTONGR, Village Council, to honor their settlement and maintain the status quo and normalcy, and to amicably resolve their dispute by an order dated 11/5/2018. Thereupon, on 15/5/2018, a joint resolution, council resolution, was adopted by the petitioner number 1 and the Metongar Village Council. And it was unanimously decided to transfer the matter to the Tikhi Tribal Court Council, TIKHIR, Tribal Court, Tribal Council Court. The Tikhi Tribal Council Court, by an order dated 9/6/2018, disposed of the said dispute. Observing that an amount of rupees 50,000, that is rupees 25,000 on account of the value of the land, and another amount of rupees 25,000 on account of maintenance and firewood, be paid to the respondent number 1 by the petitioner number 1 on or before 24/6/2018.
Full stop. Against the order, an appeal was preferred under section 31 of the rules for administration of justice, rule 31 of the rules for administration of justice and police act in Nagaland 1937, for short the rules of 1937, by the respondents herein. And what is this order thereafter? What is this order passed by the district customary court?
Lordship, this,
Page 75.
Lordship, the respondent village actually has gone on appeal against the order of the.
Against that appeal, it was referred to the Dobasi court.
Yes, yes, Lordship. It was again referred to the domicile.
And that was interfered by this court and directed the deputy commissioner to dispose of the appeal.
Lordship,
This is the order of Justice, the Chief Justice Ajay Lamba. Kindly come to page 83.
yes, Lordship, that order was passed when the matter was pending before the deputy commissioner. The matter was just, the matter was pending for almost a year. And therefore, the petitioner approached this honorable court. And this honorable court has directed the deputy commissioner to dispose of the case. So accordingly, the deputy commissioner, on the direction of this honorable court, has passed the judgment order dated 18/12/2019.
It is also seen that while the said appeal was pending before the deputy commissioner, the district customary law court Kifri passed an order dated 30/11/2018.
3010, Lordship.
Huh?
3010.
30/10/2018. Whereby the respondent number 1 herein was given ownership of the land and the parties were directed to be parties were directed to be bound and accept the decision as final and binding. Pursuant thereto, another order was passed on 8th of November 2018 by the District Customary Court Khifri, whereby it was observed that within 7 days, in case of the petitioner's hearing did not go in appeal before any higher court, the decision shall become final. Against that order, an appeal was preferred before the Deputy Commissioner under Rule 29 bracket 1 of the rules of 1937,
1978.
78. There is another rule. What? Rules of 78 of the Rules of Administration of Justice and Police in Nagaland Act 1978. Thereupon, taking into account that the Deputy Commissioner had not taken any action on the appeal so filed, the petitioner's hearing approached this court under Article 2 to 7 of the Constitution, which was registered as Civil Revision 6/2019. This court, by an order dated 2/12/2019, directed the Deputy Commissioner Khifri to take a decision on the appeal within 15 days from the date of the said order, and the decision be conveyed to all the concerned parties. It was also mentioned that the decision be taken after giving due opportunity of hearing to all concerned. Pursuant thereto, on 14th of November 2019, the Deputy Commissioner Khifri, that is the respondent number 3 herein, had issued summons to both the parties to appear and bring all supporting documents to represent their respective villages for the hearing. Thereupon, the order was passed on 18/12/2019, whereby the decision which was taken whereby the learned district, the respondent number 3 observed that the land sale between the respondent number petitioner number 3 and the respondent number 1 on 18th of December 2000 should be honored by all concerned, and any attempt to object to or reverse the sale would result in breach of trust that these two individuals have placed on each other while making the sale, and a breach of human trust on each other in general. It was further observed that the firewood that was taken by the petitioner number 1 village should be returned to the respondent by the persons concerned within 2 months of the said order. It is against that the present appeal, present revision application is before this court. Full stop. And what happened to this appeal, which was filed earlier? There are 2 appeals. One is against the DB court, customary court, and the other is against the council. What happened to that council?
Lordship, against the decision of the council, an appeal was preferred before the TB's court. And the TB's court passed an order in favor of the respondent village.
You filed an appeal on the 31 to the deputy commissioner.
Yes, Lordship.
Then the council's thing, can a council's order be referred to a DB? No.
No, Lordship.
Then what happened to this appeal? There are 2 appeals filed.
Yes, Lordship.
One is under 31. That I understood. But what is the 29 business? There's another act. Madam, there's no other. Only this. Which one did it decide? Appeal number 2711/2018. Yes, this is it. You filed under 29(1) of the 1978 Act. And where is the 78 Act? Is there any 78 Act?
Lordship, this case initially was adjudicated by some other council actually.
Understood. Where is the 78 Act? Is there any 78 Act?
I don't think so.
Then under what provision, which appeal was being filed? Anyways. This court have duly perused the order. This court have duly heard the learned counsels for appearing on behalf of the parties and have given due consideration to the respective submissions. From a perusal of the rules, from a perusal of the this code duly takes note of that the rules for administration of justice and police in Nagaland, 1937, duly holds the field. For administration of justice and police in Naga Hills district. The order so passed on 18th of December 2019 has to mean an order passed in terms with Rule 31 of the Rules of 1937. From a perusal of the rules of this court finds it relevant at this stage to quote Rule 31, which is very relevant for the purpose of deciding the issue, for the purpose of deciding the instant proceedings. Rule 31 reads as under. From a perusal of the above provision, quoted provision, it would be seen that an appeal lies from the decision of the Mojadar, Gaubura, chief headman of Khels, Dobashi, or other duly recognized village authority to the tribal court whenever constituted, or otherwise to the deputy commissioner or his assistant. The appeal, therefore, which have been decided by the respondent number 3 has to be construed to be an appeal against the order passed by the Dobashi court. It further stipulates that a record shall be made of the matter in dispute and the decision of the village authorities. Further to that, the court, if necessary, shall examine the parties, and if the decision appears to be just, shall affirm and enforce it as one of its own. However, the most important aspect is what happens when the deputy commissioner or his assistant reverses the said decision, or has doubt on the said decision of the customary courts. The said rule categorically stipulates that if the deputy commissioner or his assistant sees reason to doubt the justice of the decision, it would try the cases de novo or refer it to the panchayat as above. Therefore, from a perusal of Rule 31, it categorically shows that if the deputy commissioner or his assistant, upon examination, or his assistant, is of the opinion that the decision rendered by the customary courts are just, they shall affirm and enforce it as its own. However, in the case it doubts, the deputy commissioner is required to try the case de novo. In the instant case, this court have duly taken note of the impugned order, and more particularly paragraph number 7, wherein the deputy commissioner mentions about the admission made by the petitioner number 3, as well as certain shared history and kinship between the petitioner number 1 village as well as the respondent number 2 village. Thereupon, the respondent number, thereupon the deputy commissioner, by the impugned order, reverses the decision of the Dobashi court, dated 8th of November 2018, dated 30/10/2018 and 8th of November 2018. On merits. Under such circumstances, this court, during the course of the hearing, perused the LCR which have been placed before this court. It, however, surprises this court that there is no document to show that there was any de novo trial conducted. This court also finds it very pertinent to take note of Rule 26, which stipulates the manner in which of the rules of 1937, which stipulates the manner in which the proceedings are to be conducted by the customary courts. Unlike Rule 26, the Deputy Commissioner, in terms of Rule 31, if it doubts the decision of the customary courts, would be bound to try the cases de novo. The de novo trial, the trial that was de novo, and also there is there is a requirement that a record shall be made of the matter in dispute. The de novo trial to be carried out by the Deputy Commissioner or his assistant, in the opinion of this court, has to be on the basis of filing plaint, allowing the other party to file written statement, and thereupon to proceed with the framing of issues of the dispute and recording of evidence. In the opinion of this court, the Deputy Commissioner The records does not speak anything was done in that regard. And the learned deputy commissioner had reversed the decision of the Dobashi court dated 30/10/2018 in the opinion of this court, the learned deputy commissioner had failed to exercise the jurisdiction conferred upon it by law. And accordingly, the impugned order dated 18th of December 2019 is interfered with on the ground of jurisdictional error. This court, however, further restores the file of the appeal bearing receipt number 994 dated 27/11/2018 to the file of the Deputy Commissioner, Kifri, Nagaland. This court further observes and directs that in the circumstance the Deputy Commissioner shall decide, the learned Deputy Commissioner Kifri shall decide the said dispute in terms with Rule 31 of the rules of 1937. Without being influenced by the order dated 18/12/2019, which have been set aside herein. It is further observed that in the circumstance the Deputy Commissioner would be at liberty, would be on the basis of the materials placed, would be at liberty to confirm the decision of the Dobashi court, and if it doubts the decision, the learned Deputy Commissioner shall carry out de novo proceedings in the manner above observed. With the above, the instant petitions stands allowed. Why it happened, you know? It was because of the order passed by this court earlier. The court could not have directed that within 15 days you dispose of Rule 31. Because 31, the moment he does not confirm, he has to go for a de novo trial. That's already a full bench decision on that. So once you go for it, it will take us a long time. The problem, that is why the Deputy Commissioner made the mistake. They had no other option. When the High Court directs you within 15 days, you dispose. Chalo, the fat file goes.
For admission, item number 4.
May please, Lordship. Lordship, here in this matter, the stake we had filed an SLP, and the matter could not be taken up because the Supreme Court is on holiday. So, Lordship, I pray that the matter may be listed after
This is
4
against
weeks.
which order?
Lordship,
Against which order?
Against the order passed by the division bench, Lordship, because against this single bench order, an appeal was preferred by the state, which was dismissed, Lordship.
here the petitioner, he does not come under either of the OM 2004 and 2015 for regularization of service. The single judge has directed to regularize his service, against which we filed a DB. However, the division bench has dismissed our appeal, Your Lordship.
You got to stay.
Lordship.
You have got to stay.
No, we have not got a step, because it could not be listed because the Supreme Court is on holiday, Your Lordship, so.
Now, against this order, there was an appeal.
Yes, we prefer an appeal in the division bench, Lordship. And this year, the division bench has dismissed our appeal. So right after that, we have filed an SLP, but it could not be listed.
Have you filed your reply?
No, Your Lordship, I have not.
Then
Then, Your Lordship, in that case, 4 weeks time may be given so that,
isn't the necessity of first purging the contempt necessary?
Lordship,
Isn't it the necessity of law that you have to first purge your contempt by filing an affidavit?
Lordship, I will file.
Then,
it. Yes,
You
Lordship.
have not filed an
Lordship,
affidavit.
Lordship,
That cannot be a reason when
Lordship.
there is no stay, not an appeal.
True, true.
As of now, you have filed or don't file, haven't filed, it's not
Lordship.
known.
No, Lordship.
Is there, have you got a filing number? No.
Only the diary number, Your Lordship.
You have not got even a filing number.
No, Lordship.
You are thinking that you are going to file after reopening on 7th of July. Then
Lordship,
it cannot be a ground.
yes, Your Lordship, 4 weeks time may be granted to me to find my content, Lordship.
A person he is asking for his, he has to get his retirement benefits.
No, Lord.
Then
Lordship, he is a work charge employee. He does not come within the
he was
policy
on
of,
scale of pay.
no, Your Lordship.
Then
He was
as
on
per
fixed
your,
pay.
huh?
He was on fixed pay, Your
Then as per
Lordship.
your own submission
Yes.
made before that, when I was sitting in court number 1,
Mm.
that for them, 2004
Yes,
notification
2004
comes to play.
notification. So,
Then it is not even required over 30 years.
So-
Here is a case over 35 years.
so,
There's a Supreme Court judgment also in Nisiba or something. What is that? What
So-
is the judgment in Nisiba? There's a judgment now?
Kalsibai, Lordship,
Hmm.
as well as Prem Singh, Lordship.
Yes. Wherein it has said that you keeping a person there for 35 years, you can't do that. You file your affidavit
Lordship,
when?
Lordship, can you grant me 4 weeks time or 3 weeks time? Lordship,
Date fix. There's a
Fix,
lot of
okay.
the time,
Okay.
2022 matter has been pending. Okay. This court grants a last opportunity to the respondents to file their affidavit by 5th of July, 2024.
Make it after 5th, your Lordship.
Why? We can make it before 28th of June.
Your Lordship,
For
make
filing
it-
an affidavit, how much time does it take?
Okay, Lordship.
And if you don't get a filing number by
Lordship,
then
lordship,
also it
lordship.
has, then God save you.
Mhm. Okay,
Yes.
Lordship, much obliged.
Obliged, my lord.
List the matter on 7th of, 8th of July, 2020.
Much obliged. For admission, item number 5.
No, please, Your Lordship.
Yes, madam.
Your Lordship, in this matter, the respondents number 1 and 2 has been transferred. So respondent number 1 and 2 has been transferred. So allow me to implement the new incumbents by filing appropriate application.
It has been submitted by the learned counsel appearing on behalf of the petitioner, the petitioners, that the respondent number 1 and 2, that the present incumbent, that the no respondent number 1 and 2 are no longer holding the post of Home Commissioner as well as the Commissioner of the Government of Nagaland, respectively. She therefore submits that some time may be granted to her for filing appropriate application to implead the new incumbents after taking due steps. List the matter of the 6 weeks.
2 weeks.
No, madam, you have to inform them. They look here, there is an order. Kindly do it because it is personal. Yes.
Much obliged.
You have to inform them no, that you comply with this order, then only you can file.
For admission, item number 6.
Yes, what is this matter?
Actually, I'm not sure regarding quashing of the FIR.
Why?
Dimapur PS.
What is this FIR?
FIR is page, Lordship,
13.
13, 14.
Yes.
Please, Your Lordship.
Lordship, I'm appearing for respondent number one, Lordship. And Lordship, while the matter was pending, Lordship, and while the petitioner was under custody, they approached the respondent, Lordship, to come to a compromise date, Lordship. And when he was under custody, they entered into an agreement, Lordship.
Slowly.
They enter into an agreement, Lordship. And Lordship, so we did not file our affidavits, opposition, Lordship, since the matter was compromised. However, now they are coming to, they have filed their additional affidavit and also the IS stating that he was pressurized, Lordship. He was the accused. He was tortured, and the agreement was made, Lordship. So if they are not coming to this agreement, Lordship, we might need to file an affidavit, Lordship. Lordship, they have annexed the agreement, Lordship, in their additional affidavit, Lordship.
Lordship, yesterday I have filed the additional affidavit stating some facts which was not taken.
So there is no agreement.
Lordship, there is an agreement, Lordship, that was executed between the petitioner and the respondent, Lordship. However, now they're alleging that
Have
the
you brought
agreement.
on record the agreement?
Lordship, we actually even on the several occasions, Lordship. Since the petitioner did not sign, we could not produce this agreement before this court. However, even on the last occasion, Lordship, that was on 26.
I have annexed in my affidavit.
Lordship, they have annexed, but
Additional
on 26 to 24, Lordship, even here we prayed before this court that since the compromise agreement could not be produced because the petitioner did not sign, Lordship. However, now.
Deed of agreement for settlement on 11th
Yes,
of
Lordship.
January.
And in fact, Lordship, the respondent here has already received the amount that he has asked for, Lordship.
Huh?
They have already paid the amount, Lordship. The petitioners have paid to the respondent already.
You have received the 14 lakhs?
Yes, Lordship. That is what.
Lordship, it is forcefully taken inside the police when he was a police custody on 9th of January. And previously, prior to that, we have filed this criminal petition in the month of July 2023. Subsequently, he was arrested in connection in this case on 6th of January 2024, Lordship. And during he was in police custody, he was they have taken a check from the petitioner, who is the petitioner wife sent from the Gauhati because he was tortured inside the police station.
Now, have you paid the money to him? 14 lakhs.
There is no dispute regarding that. We have already supplied all materials.
No, madam.
Yes. Can one?
No, forget about that. Have you paid the 14 lakhs?
Yeah, 14 they have received.
So you have paid.
Yes.
So you have nothing to do with that.
Yes, Lordship.
No, Lordship.
So on the basis of that, why should we go into all these things? If you have nothing to that, you
Yes,
have you withdraw
Lordship,
that.
in fact, Lordship, that is why since the agreement was executed, so we did not file the objection, and we were ready to close the matter, Lordship.
Huh?
We were ready to close the matter, Lordship. We had no issue in quashing the FIR. However, now they have filed the additional affidavit stating that we took in under pressure. He gave the money under pressure. Now they are stating that so it's a misleading,
But
Lordship. It is highly
has
misleading.
he filed any FIR?
Oh, Lordship, that was the FIR that was before the receiving the amount, Lordship. And while he was arrested, while he was under custody, the agreement was made, Lordship. So the agreement was made, and the matter was fixed, Lordship. So even he took the benefit of this agreement while the bail was granted, Lordship. So we were ready to quash this matter. We had no objection to this thing, Lordship, to this petition. However, now they are coming to the with the additional affidavit stating that we pressurized him, and there are so many allegations, Lordship, made against him.
Yeah,
Are you going to file any FIR against all these allegations?
No, I have not filed any.
No, are you going to file?
I have not asked my client, but against that, probably he will not file any FIR.
You get your instruction, we'll have it at 2. Get your instruction as to whether you want to file against the forceful taking of the
Lordship,
people.
my submission maybe.
No, get your instruction then later on, because I will record that and then quash that. Because she has no problem in quashing because of
Yes.
but you are not going to insist on the allegations.
Because,
made in the
Lordship,
addition.
I have made the additional
No,
affidavit only.
Madam, kindly appreciate. Otherwise, I'll give her time
Only
for
1
filing
minute,
reply.
Lordship. Only 1 minute,
There
Lordship.
is no stay, but otherwise anything, only if you agree, if you say that you are not insisting for filing an FIR against those allegations which are there in the additional affidavit, then we are
Then, yes, Lordship, I am coming. Only 1 minute.
2 o'clock.
Who-
The accused is the habitual offender law.
Who?
Lordship, I have filed several applications. I have mentioned in my case also. He is not habitual offender. It is a organized crime committed by to him by some police along with police and someone advocate also involved. I will show in this case. That is why I am not submitting.
Madam, you only take that instruction
Yes, Lordship.
as to whether you would file any or take any action on the basis of the
Yes,
allegations made in the additional.
Yes, Lordship.
If you say that it is no, then we are going to close and
Yes,
quash the FIR.
Yes,
Otherwise, if it is there, then obviously she will have a right to reply
yes,
at
Lordship.
2 o'clock.
Obliged.
For admission, item number 7.
File the affidavit.
No, my lord.
Somehow, one thing very good about here is the filing of an affidavit in respect of criminal, what, complied.
We have, yes, my lord, we have sent a proposal to the government for appointment of
Huh?
we have sent a proposal to the government for appointment of the petitioner along with another person on compassionate ground, my lord.
What is the name of the petitioner?
Wang Nao Konyak, my lord.
Wango Konya.
He is at serial number 1 as per the updated list, my lord.
Yeah.
Yes, my lord. As
So
per
he
the
will
list,
be duly considered.
yes, we have already sent a proposal to the government for appointment along with the person figured at serial number 1 and 2.
We close it.
Yes, ma'am. But the petitioner is not.
Not necessary.
Yes, sir.
The contempt is between them and me.
Yes, sir.
And once he brings it, it is between me and you.
Yes, sir.
So what it means? Now, this is an application under section 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution, for initiating contempt proceedings against the respondents herein on allegation of willful and deliberate violation to the order passed by this court in WPC number 161/2022. So this court finds it very relevant to take note of that by an order dated 30/9/2022 in WPC number 161/2022, this court disposed of the said petition, directing the concerned respondents to consider the case of the petitioner strictly in terms with the revised compassionate appointment scheme for the state government employee who die in harness, notified by office memorandum dated 17/9/2015, issued by the Personnel and Administrative Reforms Department Administrative Reform Branch, Government of Nagaland, within a period of 4 months from the date of receipt of a certified copy of the order. It was made clear by this court that considering the case whether the seniority of the petitioner's application should also be considered. Full stop. In pursuance to that, as there was no compliance to the order passed by this court dated 30/9/2022, the instant contempt application has been filed. Today, Mr. So-and-so appearing on behalf of the respondent number
2 and 3.
2
And 3.
and Mr. Today, I've heard Mr. N. Angami, the counsel appearing on behalf of the respondent number 1 and Mr. So-and-so appearing for the respondent number 2 and 3. The counsel appearing on behalf of the respondent number 2 and 3 draws the attention of this court to a document, to a communication issued by the Inspector General of Police Administration, Nagaland, to the Home Commissioner, Nagaland. From a perusal of the said communication, it is seen that it has been stated that the petitioner herein is at serial number 1 and the petitioner is eligible to be considered for appointment on compassionate grounds in terms with the office memorandum dated 17/9/2015. Considering the above, it is also seen that in view of the urgency and the orders passed by, it has also been stated that in view of the urgency and also in the light of the orders passed by this court, the appointment of the approval of the government was sought for appointment of the petitioner and one Sri James K. on compassionate ground against any grade 4 vacant post available in the department. First, this court also finds, the said document is kept on record and marked with the letter Y, X. The learned counsel appearing on behalf of the respondent number 2 and 3 further places the seniority list of the compassionate appointment application from 2016 till date. In terms of the said seniority list, it is seen that the petitioner's name is at serial number 1. The said list is kept on record in terms with record and marked with the letter Y. Taking into account the specific stand which have been stated by the respondent number 2 and 3, and there is a submission made by the learned counsel to the effect that immediately upon the vacancy arising in a grade 4 post, the petitioner would duly be appointed. This court takes the same as an undertaking given by the respondent number 2 and 3 before this court. This court further, under such circumstances, this court would not like to further continue with the instant contempt proceedings in view of the sufficient compliance to the order passed by this court on 16/39/2022 in WPC number 161/2022. This court this court, however, observes and directs that immediately upon a vacancy arising in grade 4, the petitioner herein has to be the first to be considered for appointment in view of the fact that the petitioner is at serial number 1. With the above observations and directions, the instant contempt proceeding stands closed. Keep this on record, X and Y.
For admission item number 8. Please, Your Lordship.
Yes.
Lordship, as per the direction of this court on 14/5, we'll be filing the affidavit during the course of the day.
You are filing?
Yes.
Petitioner. Yes, what have you done to this thing? The judgment? No appeal?
No.
Isn't it my judgment? Yes, it's a long judgment in the court I gave.
Yes, as per this court direction, we have done the survey, Your Lordship.
Ah.
Yes, and we have found that most of the petitioners, they are not entitled for compensation because they are in occupation of the access area.
So therefore they filed this thing, the contempt.
Yes, they filed a contempt.
So anyway, so you want to file a reply?
Yes.
When?
We'll be filing during the
The
course of the
counsel
day.
appearing on behalf of the respondent, petitioner submits that the affidavit in reply
To respondent number
7.
7.
to the affidavit filed by the respondent number
7.
7 would be filed during the course of the day. This the matter again.
Lordship, I have a prayer. Lordship, I received instruction for respondent number 8, so I'll be filing my affidavit. So
The
maybe
Ms.
given-
V. Sukro, the learned counsel further submits that she also have received instructions that is the same submission made earlier also.
Now I received the instruction, Your Lordship.
You see, Ms. Rizal appearing on the also has some time to obtain instruction and file.
I got the instruction.
Submits that she has already received the instructions from the respondent number 8
Mm.
and is in the process of and is preparing the said affidavit to be filed as early as at the earliest convenience. So taking into account the above, this court fixes the matter again on 2nd of July, 2000.
Lordship, make it 3 weeks maybe granted to me. Your
3
Lordship.
weeks. I'm giving you 3 weeks now only. But today is only 12, 11. 1 week, 18. 2 weeks, 25. 3 weeks, 2nd.
Okay, much blessed.
2nd of March. July 2000.
For admission, item number 9.
Yes, madam. What are you doing? Challenging here?
May I please, your lordship, this instant petition under section 482 of the,
FIR quashing.
yes.
What is
your
the
lordship.
FIR?
Page 12,
Page
page 11 and 12.
11. With due respect, I would like to state that I've come to District Mon, Nagaland for election duty and stayed at Don Bosco's in a second. I could not find my, what? My SOS life? What is that? Where's the type copy?
Lordship, there's no type copy.
Okay, what is this thing? I could not find my, what is this?
Insas rifle.
Huh?
It's an Insas rifle.
SOS rifle
Insas rifle.
or
I-
just rifle magazine and
No.
20 rounds. So saw CCTV footage and found Tulsi Air talked about the above mentioned item from my bag and 20 ways. So kindly raise the hand. Yes, you want to quash this?
Yes, lordship.
Why? How can you quash it? It's a question, serious case of him losing a SOS rifle. Question does not arise. Don't go for quashing. Where's your senior? Senior have seen that this case is bad, so she has sent it to you. Huh?
Lordship,
Something like that. Otherwise, why?
My senior is out of station.
Ah. Can't help it.
Lordship, the instant,
You don't have a case. This cannot be quashed. Here is a losing of an SOS rifle or what is the name? I forgot.
Insas
Intas.
rifle.
I-N?
INSAS.
Inas.
Insas.
Insas
rifle.
Rifle Magazine.
No.
INSAS Rifle Magazine. Okay. You losing this is a question of investigation. Whether it has been done against you or not, you want a bail, go for a bail. Have you got a bail or not? Huh? How many years of practice?
just last year.
Huh?
Started. I joined last year.
Last year,
Yes, lordship.
late part. Okay, we adjourn it. Late part. Taking into account that the counsel for the petitioner is taking into account that the counsel representing the petitioner, the the counsel representing the petitioner who was to advance the argument is unavailable on account of certain personal difficulties. Matter stands adjourned to be listed again on, now catch hold of a bad day for you, 25th of June. That day.
For admission, item number 10.
Yes, what is
May I
this?
please, Lord? My lord, this is
Yes.
the bail application, my lord. My lord,
NDPS
yes, my,
21C
Correct.
commercial.
yes. my-
Lordship.
The,
Lordship on this last.
What is the stage of investigation?
Lordship, charges have not been filed.
Huh? Charge sheet not submitted.
even statutory period,
How much?
even statutory period is over now, when the
Huh?
case is, when the bail is pending here. This
Period
bail
is
was-
over?
No.
Yes,
Then,
That-
then go there.
When my lord, this bail was filed on 17 May,
Ah.
before this normal court. And the statute, that time statutory bail order was not over. During the pendency of this bail, the statutory bail of 180 days expire on 9th.
Of
This is 11.
9/6.
Yes,
2024.
this has been pending for
You were
too long
arrested
time.
on
arrested on 12, 23, my lord.
12/12/2023.
Yes, my. Then
And-
cognizance was
and
taken on
s-
13/12.
Huh?
Cognizance was taken by the magistrate on 13/12.
13/12.
Yes,
Okay. Now, in view of that provision, what is that? 36.
36.
36 says what? There are two options. Either it may also be extended, but did you approach the authority? The
The-
court?
That was rejected. They approached the court for extension of time. It was rejected.
Where is that order?
It's
You will have-
in the city law.
So therefore,
Then why didn't you get the bail there?
lordship, my problem was bail was pending here.
Oh.
Yes, so in fact, this is the third time the matter, because this number court has directed to produce the case diary. So in second occasion also.
Lordship, I have like that one, Lordship.
Yes.
Dated 3/6/2024, last.
Three,
Yes.
six.
Dated 3/6/2024.
Receive bank details of so and so awaiting reminded I close the year. What is this?
Note.
Note?
Note. Reminder the
Note.
FSL to provide the expert opinion. Direction has been given to start preparing charge sheet after receipt of the FSL report. The court has not allowed for extension of mandatory period of investigation.
180 days was one. Beyond that, the
lower court.
special judge did not allow.
Now, did you ask for? For the purpose of you need some more time for a year, you asked
Not
and you
yet.
did receive.
It was
Okay, we then, what to do? Grant the bail here?
Very much. But even otherwise, on merit, I was just arrested on suspicion. I have a few
Merit,
judgment.
Let us not go into the.
Oh, my, yes, my lord. Same thing.
Like I heard Mr. A. Joe, the learned counsel appearing on behalf of the petitioner, and Mr. V. G. Momi, the learned counsel appearing on behalf, learned PP appearing on behalf of the respondent state. This is an application for grant of bail under section 439 of the CRPC 1973 in connection with narcotic police case number 02/24 under section 21(c) of the NDPS Act 1985.
Yes,
From a perusal of the records, it reveals that from the perusal of the materials on record, it reveals that the petitioner herein was apprehended on petitioner or who?
no, accused, my
The accused. Who are you?
petition, brother of the accused.
The accused, namely, what is his name?
S. Nasher.
S. Nashu.
Yes.
No, Mrs.
She's
accused,
she's
namely-
single mother, my.
Mrs. S. Nashu
Yes,
was apprehended on 12/12/2023
Yes.
at around 3:30 p.m.
yes,
by the Senapati police personnel at Kloberg's shop in Senapati town, Manipur. Subsequently, on 13/12/2023, the Nagaland police personnel went to the OC Senapati police station, Manipur, and taken the accused to Kohima North Police Station, Nagaland, and produced before the magistrate. Full stop. It has been further mentioned that at the time of filing of the instant bail application on 26/2024.
17 May.
It is
Bail was
26.
filed on 27. Bail was filed on 17 May 2024.
No, 26 it is mentioned. On 25. 25, it is the date. On 25, 2000, if this is the name, what is the name is Thong Gua Lao. Isn't that?
Oh, yes, yes, Thangolo, yes.
Then 28th of May 2024, the accused have already been in custody for 160 days. In as much as the affidavit was filed on 17th of May 2024 stating that the accused was in custody of for 157 days. The learned counsel submits, or the petitioner submits, that the mandatory period of 180 days.
80 days, 180 days,
In terms with section
36.
36. NDPS Act.
36A. 36A4, my lord.
In terms with section 36A.
Page 27. Page 27 and the relevant paragraph, page 28.
36 capital A.
Page 4.
4.
Yes, last sentence, my lord.
Have already expired of 180 days have
Yes.
already expired on
9/6.
How?
2000, because cognizance was taken on 13th.
Huh?
13th. Cognizance was taken by magistrate on 13/12. Yes. 13/11.
No, if it was 160 days on 28th of May, then 20 days more is when? 28, 10
lord.
days and today is 10th.
My lord, this not this file case was filed on 17 May.
17 May, you said 157 days.
Correct, correct.
So 28th May, another 3 days is 160 days. Now next 20 days is complete when?
11 June.
Ah,
This month, 11 June. Correct.
so therefore, no, it can't be 9/6. That on 11th of June 2026, today is what? Today is
9/6,
11.
9/6, 9/6.
How?
180 days expire on 9/6.
How?
Because she was arrested from the date of taking cognizance by magistrate.
As per your petition,
Yes.
157 days. On 17, 20 days, how much?
My lord, but the right calculation will be from the date of taking cognizance.
13.
Yes, 13/12. So that then 180 days expire on 9th June this month.
How?
Yes, lordship. She has been in jail for 6 months, 2 days. 6 months, 2 days today. 6 months, 2 days.
What do you say?
Yes, correct. She was arrested on 13/11/2023. Exactly 6 months, 2 days, my.
13th May.
Sure. Therefore, mandatory period expire on 9 June.
This time 29 days. Every 29. Ah, 9th.
Yes, yes.
Exactly on 9th.
And Lordship, another aspect, out of 12 accused here, all 10 have been released. Only 2 left.
And submits, Mr. Ejo, the learned counsel submits that taking into account that the petitioner was arrested, was produced before the learned magistrate on 13/12/2024.
Yes,
The mandatory period of 180 days expired on 9/6/2024.
yes, madam.
Full stop. He further submits that the special court had also not granted extension
Yes. To the IO.
in terms with the proviso to section 36A4. Full stop. This court have also perused the case diary which has been produced by Mr. V. Chimomi. And from a perusal of the case diary, it is also seen more particularly
Page, please.
on,
Page
more particularly that the,
The
particularly,
3/6/2022. Last page. CD number 48,
Second last page.
second last page.
Second last
Number-
page.
oh, this is the old city. More particularly on 3/6/2024, it has been duly mentioned that the court had not granted the extension of the mandatory period of investigation. First, under such circumstances, in view of the provision of section 167 of the Code of Criminal Procedure 1973, read with section 36A(4) of the NDPS Act 1985,
Yes.
further custodial incarceration of the petitioner cannot be permitted in view of the law well being settled. Under such circumstances, this court grants the bail to the petitioner subject to the following conditions. Hey, kita condition kita didi. The case diary, the photocopy of the case diary of, I think we should return it.
Yes, we should.
You should not keep the case diary records here now. The case diary so produced is returned.
Much of it.
It is granted bail in Hekta Likidi. This also take it, don't keep it. The case diary is something it is more
Yes.
confidential.
Yeah, better.
You can't give a photocopy like that.
We are not entitled.
Eh?
I am not entitled. Much of like.
For admission, item number 11.
Yes, what is this?
May I please, Your Lordship, here the petitioner left husband vehicle.
Seized vehicle, white Alto covered by so and so, should not be released on Jimma under such terms and conditions. Yes. Why you are not giving it?
Lordship,
Nowadays, to in view of the judgment of the Supreme Court, too, he can very well do it under 457 there. Isn't that the latest judgment?
Lord,
I think that is the judgment of really regarding really with reference to the Iman, the mentioned winner was forwarded to the Honorable Court of Guidance to the inspector and further after completion of investigation. And what is this?
uh, Lordship, the seized vehicle has been submitted to the lower court below. Lordship. Since the investigation, everything is done. Lordship. This is the instruction from the IO, of the.
What is there in the vehicle? What did you catch? What did you catch hold of in the vehicle?
Lordship, from the seized vehicle, Lordship, the amount of this
Huh?
sunflower.
Well, nothing was seized from the vehicle. The vehicle was seized on 3 September 2023. And the accused is only released on bail, on default bail. And the accused, the petitioner's son approached the lower court, but his Jima application was rejected. So now the the accused mother, who is the wife of the late owner, have a process on oral court to consider her prayer. And my lord, during the hearing of the Jima in the lower court, the special prosecutor have himself stated that there is no place in the police station for the safe keeping of the vehicle. It is just kept outside the police station, my lord. And unless the lower court intervene,
You give me a printout of this judgment. Giving it to you in WhatsApp. Internet here is very bad.
beg your pardon.
Internet in Kohima is very bad. I'm going. Yes, they're gone. Now, why do you need the vehicle?
My lord, this
Lordship, as
Who
far
is the owner?
the owner have expired.
Who are you? You are the person who are
I'm the
carrying,
wife of the owner. The
you were,
petitioner
were
is
you
a-
carrying the sunflower? Consignment is of what?
actually nothing was recovered from the vehicle.
Nothing.
Yes, nothing, my lord. It was recovered from the roadside, my lord.
From the roadside.
Yes, my lord.
Lordship, nothing, since nothing has been mentioned, Lordship, as far as the instruction that I received from the IO, they have clearly stated that since the investigation.
Let's see the order passed by that court. Learned counsel submitted in Iman and import on the Intel worker so and so, so and so. Personal abandoned, black polythene abandoned on the roadside containing suspected. On inquiry, it was learned that the suspected illegal substance belonged to the occupants of the aforesaid vehicle, which was bound for worker. Oh, you're not inside.
No.
Then I think you have no business. Are you looking for the sediments of the sunflower in the vehicle? Something to that effect.
Lordship, since after the investigation was over, investigation and inspection was over, it was handed over to the lower court below.
I'm inclined to release the accused persons on default bail. The accused persons have been already released. What are you going to do with the vehicle? Tell me, give me a good reason.
Lordship, I'll leave it to your lordship. Since as far as the IO of the instant case, he has stated that investigation is and the inspection is already over. And since that said vehicle has been handed over to the lower court below. Lower court.
What is the lower court going to do? Is he going to use it for itself?
Lordship, here it is stated
And
police
after
court work-
completion of investigation through the Iman, working challan is so the mention have been forwarded to the ER.
police court.
So investigation is over.
Lordship.
No, release the vehicle.
Lordship.
Okay. This is an application filed by the wife of the owner,
Yes, my lord. Late owner.
wife of the owner
Yes, ma'am.
of a vehicle being Alto 800 bearing registration number NL01H-6624, which was seized by the Waka police in connection with GR case number 113/2023 in connection with Waka PS case number 76/2023 under section 21B NDPS Act read with section 183 of the MV Act. The owner of the vehicle had in the meantime expired.
Yes, ma'am.
And on 10/6/2022. And under such circumstances, the instant application has been filed by his wife.
Yes, ma'am.
Pursuant to the notice filing of the instant petition, this court asks Mr. V. Jimomi, the learned PP, to obtain instructions by an order dated 4/6/2024. Pursuant thereto, Mr. V. Jimomi, today, Mr. V. Jimomi has produced an instruction issued by the investigating officer of Walker PS case number 76/2023, wherein it has been mentioned that the entire investigation and inspection have been already carried out, and as such, the vehicle has been forwarded to the court at Walker, learned court at Walker. Full stop. Taking into account the above, this court is of the opinion that no further purpose would be served in keeping the vehicle by the investigating authority or in the custody of the learned court. Accordingly, this court directs whom? Direct whom?
The Honorable Special Court,
The
Special Judge NDPS.
Huh?
Oka.
Judge NDPS Walker.
directs the Special Judge Walker, Nagaland,
Yes, ma'am.
upon being approached by this court, by the petitioner hearing, to release the said vehicle bearing registration number NL, to pass appropriate orders for release of the vehicle being NL 01H 6624, which was seized in connection with Walker PS case number 76/2023. Upon production of the necessary documents showing the ownership of the vehicle.
Yes, ma'am.
Full stop. The same be done, full stop. The same be done upon the production of a certified copy of the instant order and the approach made by the petitioner hearing before the learned special judge
NDPS.
Walker within a period of 15 days thereof. Immediate, as early as possible and preferably within 15 days.
Yes, ma'am.
15 days is okay, or should I make it less?
Less
How much?
to 5 days.
5 days.
5 days, ma'am.
Complete.
Yes. For you.
Last. Hello, please.
This is a very important judgment on that. Now, what has happened is that earlier there was a thing that all matters have to be done by the High Court.
Lot.
451 power was not enough for the purpose of the trial court or that magisterial court to grant the custody. The Supreme Court said no, because there was one another judgment. They said no, you have to, because this is very relevant, because there is a division bench which was order passed by this court, which said that no, you cannot do it before a year. Therefore, you have a lot of matters before this court. So now because of this, it is no longer required. He can very well approach.
No. From the supplementary cost list for admission item number 20.
What is this so old matter? Other side must have forgotten. What is this? Why is the other side not representing?
They were around. I saw them. I saw the private respondents. Lord.
You are for the private respondents?
No, I'm for state, Lord, but I saw the private respondents.
Bangyola. Oh, I taken up this matter yesterday.
Yes.
This is pertaining to that, it has already been done, nah? This is the case. What is that? This is a lawyer from Manipur,
Yes.
isn't it?
Yes.
Ah. Here the charge sheet said nothing against him.
Yes.
In fact, there is no charge sheet against him.
No, Lordship.
The investigation is over.
Yes.
Charge sheet is nothing against him.
Yes.
So nothing remains.
No, in that case, Lordship, I think he has no locus standi to challenge.
No. He challenged it because there was an allegation against him then. He challenged the FIR.
Take my lord to.
He admit he asked for quashing of the FIR. He did not challenge the charge sheet also.
I think.
The FIR has nothing. Once the FIR has, the charge sheet has been submitted where he has been, there is nothing against him. What remains?
So, Lordship, I think he has no locus standi to challenge the charge sheet now because there is another co-accused.
Ah.
So
No. Therefore, I propose to pass an order that in view of the fact that in the charge sheet it has been categorically mentioned that he has nothing
yes.
upon investigation, then not the said investigation and in the charge sheet there is no action to be taken under such circumstances and there is no charge sheet filed against him.
Okay.
Nothing remains to be decided here.
Yes, that is there, but the later.
You are appearing for?
Lordship, I'm appearing for respondent, private respondent.
Yes, what do you have to say? For you only we are waiting. Yesterday I have already heard the counsel from Manipur.
Apologies, Your Lordship.
Fantastic. Tell me.
Regarding this matter, Your Lordship, the involvement of the petitioner is shown in all the steps of the case. Firstly, when he.
What is the charge sheet?
The charge sheet has stated that the IO has stated that the petitioner has the whereabouts of the petitioner was not known since they tried to trace him. And
No.
yes, Your Lordship.
IO says here, if you kindly see this, where is that IO charge sheet? Kindly see. Kindly come to page 15 of his petition.
Yes, Your Lordship.
What does the IO say?
The IO has stated during the investigation, the arrested person alleged the involvement of Auntie Luong in the commission of offense. However, during investigation and from records available, it is ascertained that the arrested accused Abhishek Bhagat, alias Abhishek Bora, is the sole accused who had opened and registered the company from MAC ROC Shillong as the chairman of the company, MSView Image Infratech Private Limited. He also prepared and signed a letter of intent, the LOI, and affidavit agreements in order to falsely assure the complainant no prima facie concrete evidence could be established against the suspect Auntie Luong from available documents. Your Lordship, the fault of the IO cannot be one here. If the IO is not searching for available records, Your Lordship, I would like to state here that there are available records. However, the IO has overlooked.
Good, madam. What is the next course of action? Tell me.
The IO has also stated that in the course of investigation, supplementary charge sheet will be provided, Your Lordship.
Where?
In the paragraph in the last line.
The investigation.
The investigation would be revived again.
If and when any
Details of the suspect is established to ascertain.
and supplementary charge sheet shall be submitted if found involved. Then,
Your Lordship,
yeah,
regarding this, the petitioner has never cooperated with the investigation agency. In fact, he has been absconding. Then his cooperation has never been seen from day one.
then why did he come up and say that there is no prima facie case against him?
Yes, Your Lordship, he has been absconding and has not been cooperating with the investigation, and on the other side, he has been engaging another lawyer to defend himself. This is not doing justice, Your Lordship. If he is innocent from the beginning, he should have cooperated with the investigation agency, Your Lordship.
Mr. Angami, kindly tell me one thing. Here the charge sheet has been given. Once the charge sheet has been given, you have the investigating officer cannot file a supplementary on his own. He has to seek the permission for further investigation at the time when he files the charge sheet. That is the law. Did the investigating officer file that? If not, the matter is it's the end of the matter.
Because of the judgment, at first glance, I thought petition may have a case, but seeing the later part again, in that case is covered by one judgment, Hukum Cham. Now his name is reflected in the charge sheet. In that case, he has no longer right to challenge it. Again, in the same paragraph, later part, if you see it again, I'm confused whether
No.
his
That
case
is why I'm saying,
is
no,
correct.
no, you have to understand. At the time when you file your search sheet,
Yeah.
he has to tell the court that we require further investigation. And therefore, we are going to file a supplementary. The court then will give you the permission. Otherwise, no, that is the law. TRBC. So you ask your person concerned, did he answer for that? That is the only way out. If he has not asked, then they will have to file a petition out there before that court stating that we have a protest petition that he is also duly involved. Investigation has not been done, and as such request for a further investigation. If it is not being done. So this has to be done in that manner.
Lordship, in that case. Lordship, I'll make endeavor, if the matter will be listed after tomorrow again then.
Tomorrow?
Day after tomorrow, since I think there's division bench. Tomorrow.
The so-and-so, the learned PP submits that some more time, some time may be granted for him to obtain instruction as to whether the investigating officer have sought for, have pursuant to submission of the charge sheet, have sought for filing any supplementary charge sheet before the learned court. So list the matter again on 13/6/2024. What is this? This case has come, some records have come. If the records have come, then what it remains? Where did she go? Yes, madam, don't go away. Matter is still under session. Yes, here it is relevant here. Receive the FIR charge sheet, Kohima not, receive and production report along with the accused so and so. Examine, the accused has been remanded to police custody, peruse of so and so, accused Abhishek Sharma, people job. Never produce the custody of so and so, expedite investigation and submit FIR. So and so. Mention that the accused has not been produced, accused shall produce, and so meanwhile, here remember the charge sheet. Yeah. accused Abhishek is produced for so-and-so month within fixed date so-and-so. Both the parties are here at length at the court for consideration of the matter of section framing of charge under so-and-so, the accused so-and-so. We are put up today, matter is required for examination of the applicable 1 and 2. Here the check. We do one thing, okay? This the matter on 13, this the matter again on 13/6/2020 for further consideration. Taking into account the counsel for the petitioner is not represented. This is some other file also. Could be done.
Oh, sekian kami, sekian kami, sekian. Oh, kita tadi di belakang.
Hello? Hello? Hello?
Sí, yo le he querido persona, ¿verdad? ¿Ah? Sí, viene una persona, cuchillo, ¿no? Ini kunci deh. Yes.
Next one. For admission item number 6. Yes.
Lordship, I have taken instruction. He did not file any FIR.
Ms. M. Day, the learned counsel appearing on behalf of the petitioner. Mr. V. Jimomi, the learned PP, appearing on behalf of the state of Nagaland. Ms. So-and-so appearing on behalf of the respondent number 1. This is an application under Article Section 482 of the Code of Civil Criminal Procedure 1973 for quashing of the FIR in connection with suburban Dimapur PS case number 43/23
registered under section 420/406 of the Indian Penal Code. Full stop. The instant application, the grounds taken in the instant application is that the dispute in question being a purely civil dispute, the criminal action should not have been set into motion. It has, however, been submitted by the counsel appearing on behalf of the petitioner as well as the respondent number one that a deed of agreement, settlement agreement was entered into on 11th of January 2024 between the petitioner and the respondent number one, whereby the matter whereby the dispute between the petitioner and the respondent number one was duly settled and the respondent number one and the petitioner duly and in consequence thereof, the petitioner paid an amount of rupees 14 lakhs, the respondent number one. What about the dispute PS case?
In this case, police went to dispute.
What is the dispute PS case?
And the informant has, the accused has filed this dispute PS
Against?
against police respondents.
Then have you withdrawn
That is
that?
pending. That is pending.
No, Lordship, as per the agreement, both the cases, both the FIR has to be withdrawn as per the agreement. After this agreement only, it will be withdrawn there also. So,
Understood, but if it is not done, here it is quashed, then what will happen there?
Lordship, after this, the petition, the respondent is approaching the appropriate court, Lordship, for quashing, Lordship.
Understood. line लिख ले. An amount of rupees 14 lakhs was paid by the petitioner to the respondent number one. The counsel appearing on behalf of the respondent number one submits that in view of the receipt of the amount of rupees 14 lakhs, she has no objection in the quashing of the said FIR. It has also been brought to the attention of this court that pursuant to the said agreement entered into between the petitioner and the respondent number one, on 11/1/2024, the petitioner had also been released on bail by the Judicial Magistrate First Class Dimapur, Nagaland. Which also, this aspect of the matter is an indication to the fact that the petitioner herein had also acted upon the agreement dated 11/1/2024. It has been also submitted. Now, at this stage, this court also finds it very pertinent to take note of an additional affidavit filed by the petitioner in the instant proceedings, wherein various allegations have been made in respect to the deed of settlement agreement, and that the petitioner had to make payment under caution. However, the learned counsel appearing on behalf of the petitioner submits on instructions that the petitioner herein would not like to further escalate the dispute in view of the settlement. And the allegations so made in the additional affidavit was on account of a misunderstanding. This court further taking into account that this offense is compoundable, na?
Yes, Lord. 42406 compounded.
Further taking into account
320 of the.
that the offenses under which the section, the SBN PS case number 0043/2023 have been registered are compoundable. And the parties have duly agreed to act on the basis of the agreement dated 11/1/2024. Quashes the SBN PS case number 0043/2023. Please.
Maybe first.
Huh?
43 maybe
I've already quashed.
first. Obliged, Lordship.
I in view of the disposal was accordingly the instant proceeding stands disposed. IA number equals into us stands closed in view of the disposal of that. Yeah.
Obliged.
Orders item number 12.
Service not complete.
Your please, Your Lordship, with the permission of Lordship, I would like to submit give a brief submission.
Huh?
Your Lordship, here in this contempt petition,
Hmm.
I have no instruction at all, but I have appeared in a review connected matter. I have appeared in a review petition. Arose out of the command judgment dated 2019. That's also arose out of the 3 WBC 201 of
But Mr.
2017.
Imsao,
Yes.
service is not complete. Are you appearing for everybody?
No, I have no instruction at all. But since this contempt is connected with the review, which I have handled, I just want to apprise Your Lordship that a time may be granted to the state respondent.
Whatever may be, that's a different thing. Here this come up for orders. Service is not complete as
Okay.
regards respondent numbers 5 to 7. Petitioner has to take steps.
Lordship,
The office orders dated 25/2/2022, that is the last order, shows that the service upon the respondent numbers 5 to 7 is not complete. Any other office note? Considering the above, has the review petition been disposed of?
Yes, Lordship. Recently only, yes.
What happened?
The review was dismissed, Lordship.
Review was dismissed.
Yes, Lordship. And then after the dismissal of the petition, the,
matter.
yes, Lordship.
The office note dated 25/2/2022 shows that the service upon the respondent numbers 5 to 7 is not complete. Now these people may have changed again.
Yes, Lordship, with regard to that, respondent number 3, Your Lordship. For that, I may be spending
Huh?
some time. Respondent number 3 is already third, Your Lordship.
And what about the others?
Other, Your Lordship,
Finance Commissioner is the same.
for that, I have filed an IA, which was disposed on 22/2/2022,
Hmm.
where respondent 5, 6, and 7 was implemented, Your Lordship.
Hmm.
And then, but now, as of now, respondent number 3 is already attached, so for that, I have to file an IA.
Okay, we do one thing. We give you some time,
Yes,
get your instructions as to whether these people are still there.
Yes, Lordship.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that in view of the contempt proceeding having been listed after a period of 2 years, he would like to take instructions as to whether the respondent new incumbents are holding the post wherein the respondents were arrayed. Full stop. 3 weeks' time is granted for that.
Obliged, Lordship.
Orders, item numbers 13 and 14.
None appears on behalf of the applicants on call. Put it in both eyes, huh? Both eyes. Full stop. For ends of justice, the matter stands adjourned to be listed again on 26/2024. It is made clear if the applicants are not represented on the next date, the instant proceeding application shall be dismissed for non-prosecution.
For orders, item number 15.
Yes,
May I please, Your Lordship?
what are you challenging?
This criminal petition is filed under section 482 CRPC for quashing of FIR.
Okay, service is not complete upon respond number 2 and 3. For perusal of the office note, it reveals the service is not complete as regards the respondent number 2 and 3. Full stop. Huh? Where's 3? 2 and 3. What to do?
I may be allowed to issue fresh notice through Dusty service.
The counsel appearing on, you can affect Dusty
Yes, Lordship.
nearby. Or it's in the same place.
It's
Same
in
village.
Singapore. Yes, in village.
On plain end, son of Kohima medical colony, Junabetu. Medical colony. And where you stay?
I stay, my clients, they stay in Singapore.
You can affect Dusty.
Yes, Lordship. I will.
Okay, the learned counsel appearing on the office note dated 21/2/2024 show that service have not yet been effected upon the respondent number 2 and 3. The counsel appearing on behalf of the petitioner submits that she would like to take effect justice service upon the said respondents. So accordingly, this court fixes the matter again on 23rd of July 2024. The petitioner shall effect justice service upon the respondent number 2 and 3, routed through the registry of this court, and file an affidavit of service on or before the next date.
For orders, item numbers 16 and 17.
May I please, Your Lordship. Your Lordship, your service report is still awaited for the response, Your Lordship.
What?
Service report is awaited for response, Your Lordship.
What is this service for?
Your Lordship, we are yet to be represented, Your Lordship. The
You
claimant
want
has appeal, Your Lordship. And
Service is awaited.
Lordship.
Okay.
Lordship, if
So taking into account the office note dated 25/2024, this court directs the matter be listed after.
Your Lordship, if
completion
I
of
may be
service.
allowed to take substitute notice, Your Lordship. Newspaper publication.
Newspaper for IA. This is a civil matter.
Lordship. Much obliged.
This be listed after completion of service. Full stop. In addition to that, this court observed that if the petitioner wishes to take service by way of substituted mode, appropriate application, liberty is given to file appropriate application.
From the supplementary cost list for orders, item numbers 21 and 22.
Yes, where is he? Oh, yes, you are there. Where is the respondent?
I know in this matter, respondent not appearing.
Now, in one case, notice was issued on 6/6. How can we expect?
Yeah, my lord, that was this thing IA, in relation to IA.
Okay, in this case, show me.
Yes.
Now, where is this lady who appeared yesterday? For respondent number 5. She said that her senior would like to appear.
Oh, my lord, that is item number 22.
Yes, yes. that
Yes,
is what-
so this is.
We are
number
concerned
21.
with that, nah?
My lord,
Yes.
in respect to item number 21,
Hmm.
this is a civil revision pertaining to a land dispute. Now, my lord, in this matter, the village council has made a resolution. The opposite party, the respondent herein, in violation of the village council resolution, has taken up the matter before the DB court. Now here the village council, that is the chairman and a head GB, they have represented the case and they have appeared, they have filed the application before the DC's court. DC, in order, instead of taking up the matter, has endorsed it to the lower court. So the lower court, the ESC court has again endorsed the matter to the DB court. So in this particular case, DB court is trying this particular case for the second time. So for that, this civil revision has been preferred.
Item number civil revision 14.
My lord.
14.
12. Facts of these two cases are different. My lord, my prayer is in the thing. Page 9, grounds for a revision. Page 9, 10. My lord, in this matter,
Your prayer is at page 11, 12.
yes. But my grounds for revision, I'm saying.
28 to 2011, 2022 by DB Uria an order dated of the head DB Riapek.
without evidence. Then in,
No, don't come to the other one. First, let us first settle with one.
my lord,
We are concerned with 12.
12. Yes,
But the fact remains, Mr. Counsel,
yes,
notice was issued, there's some IA.
yes. There is one IA
For
along with this. This for, IA is for praying for injunction order against the sole respondent. This particular order has been passed on date of 9/5/2024. Service has been affected. I have not checked whether it has been duly received or not.
IA is there?
IA 38.
Service not affected. What to do?
Steps was taken, my lord. But here, my lord, in this particular matter,
No.
affidavit of notice has been given.
The council's problem is that I'm in your favor, but without the respondent, very difficult. Means service is not affected. Doesn't show that the service is affected. Can't take it up. I would have otherwise disposed of. But
My lord, then let this matter be listed on another date.
how do you affect the service?
It was through the court,
No, understood. You have taken normal steps.
my lord.
Can you take steps by Dusty?
My lord, Dusty, I have said to them through Dusty also,
But where is it?
but they are not receiving the Dusty.
Anyways, file an affidavit to that effect that you have gone out there, they are not receiving.
No problem.
And
The-
get a witness out there to sign and
Fine,
file an
Fine,
affidavit.
fine.
We'll take it up then.
My lord,
Dusty, if you then they don't accept, you can't help it.
exactly.
So then you have to file an affidavit that yes, I've gone out there, but yeah, has not received it.
Yes, my lord.
Hmm.
And for that, I prayed to the honorable court the other day. And the court has permitted me to make application through paper.
Paper you do
Yes.
it later on.
So that was already done.
You have done the paper?
Yes.
Where is the affidavit?
It was filed on date of 10/4/2024.
Huh?
Date of 10/4/2024. And it came out in the paper on date of 2nd April 2024.
But their notice was issued only on
No,
9/5/2020.
that is in relation to this thing, injunction order.
But here, no, this is civil division 9/5/2024. Here the first order is of 9/5/2024. How can there be a paper publication? And did you bring it? The first order is of
On
9.
early date, my lord, I appealed to the court. Dusty was affected. They have not received. So the only option is
Where is
make
the,
a pub-
where is your permission as per the order passed by this court that you can affect Dusty service? Nothing is mentioned.
my lord, it was in the court of Ibu Habang. In his court, I have prayed. And the court,
Understood, but the order should say something.
exactly, yes, my lord.
Does the order say? No.
I haven't checked the order, yes.
Yes.
Of course, with the permission of the court, it was done.
In our principal seat, we have a particular system and getting the list out there.
Yeah.
You see, and it's given in the Telegram channel, there's a hyperlink against the case number. You just put on the case number, put the hyperlink, you can get all orders passed in that case. I'm taking steps to get it done here, so it becomes easier. Once you have this Telegram or WhatsApp, they are coming up. I think the chief is coming, so there might be a WhatsApp channel where all notifications will be given, including the cause list. And they will have a hyperlink. And it has become very helpful in the principal seat. With that hyperlink, you can very well see what orders are being passed. Everything is there. So it is linked with the CIS. So it will be
I am
very.
not, this.
So next time onwards, you may
Yeah.
not have to tell me I didn't look into that order. Anyways, what do you want? I have to give you the permission for going for Dusty
Yes,
in both the cases.
no, in this particular case,
What about the other one?
the other one, the opposite party are here,
Where?
then the call. Item number 22.
They're paying? Then why are you sitting behind?
No, my lord, this one is another case.
Understood?
Yes.
Item number, that is civil division 14, you are appearing?
Yes, your lordship.
Okay, just 1 minute. Let me complete it with 12. You want to effect service by the Dusty.
My lord.
The learned counsel appearing on behalf of the petitioner submits that in view of the urgency, the petitioner may be permitted to effect Dusty upon the respondent, sole respondent.
So,
And taking into account the above, listed matter again on 2nd of July 2024. In the meantime, the petitioner would be at petitioner shall effect service upon the sole respondent by way of Dusty routed through the registry of this court and file an affidavit of service on or before 28/6/2024. The same order would be there in the IA also, huh, madam? It's IA 38. IA 38 is in, yes, 38. Okay. Now let us see the other one. Yes, madam appears out there. What is this case? You are paying for all the respondents?
Your lordship, I'm presenting 27 respondents. I'm for 27 respondents.
27?
Yes, your lordship.
Fantastic. There are only 27. All. Yes, what is your case?
my lord, this matter in relation to
Impugn order dated 20/10/2022. Where is that?
my lord, page 28.
Hmm.
Translated copy is on page 30.
30.
My lord, this is a dispute in relation to a water canal. So here, my lord, I'm one of the person who has the right to this irrigation canal. Now the opposite party, that is the respondent 27, they've objected that I'm not the owner of this particular irrigation canal. So for that, I've the opposite party, they have filed case before the KEL within the village. So in that particular case, since they have the majority of the number, the case was decided in their favor. Now, as per customary practices, since I have claimed this right, I should be given the option to swear oath. Option to swear oath. Or somebody comes to justify my claim that I also am one of the water owner. So that chance was denied to me. So for that, I have approached the DC's court. So the DC, instead of taking up the matter, the DC has endorsed it back to the DB court. So for that, I filed this present case so that this matter be taken up.
Rather than appeal lie against the KEL's decision. There's an appeal live before the DC against the KEL's decision.
Yes, I have applied, but DC, instead of taking up.
No.
Yes.
You applied where? Where's your application to the DC?
My lord, I couldn't raise my district application, but.
Then it is by the village council.
The village council has first decided the case. Then after that, I've applied before DC to be taken up, to be tried by the
Where
DC.
is the village council's decision?
Village council decision is on page 26. That is the translated copy.
Okay, so and so has given. This is in the joint court of village council upper and middle Kohima decision.
Yes.
who cannot accept upon a decision can make an appeal, and if an appeal is not made before the joint decision shall be followed. Okay, so against this is by the village council.
That is, yes.
So against that, an appeal lies to the under 31,
Yes.
to the deputy
DC,
commissioner.
yes.
The deputy commissioner should have decided it.
Yes.
But he acted in terms with 23A.
Yes.
But where is your appeal? Yes, madam.
Your Lordship, these 27 respondents, they are bona fide owners of SEPI water irrigation. Your Honors,
No, madam, I am not on merits.
Yes,
I
sir.
don't have anything to do with merits. Merits is you and he fight it out there in those courts.
yes, sir.
Simple question. He had against the decision of the village council,
Yes,
he
sir.
lies where?
Your Lordship, the first complaint was filed before the village council. And then the matter was brought before the district customary court that as per the record, and it was also well founded in the petition of the petitioner also. Lordship, there is no record that to show that the petitioner has filed an appeal before the DC, Your Lordship. There's no record, Your Lordship. And
Where
it
is
is
your
clear.
record to show that you filed an appeal? What is the number of the appeal? What is the receipt number? Tell us something.
My lord, I have made an application. And my lord, in view of this order, that is type copy, page 30. The DB court, this matter has been tried before the DB court. Now, the DB court, if this matter has been preferred before the DB court, then they will not put the word the government of Nagaland office of the DC. But here, since I have made application before the DC, the DB court is putting the word office of the DC. My lord, here in this particular case,
Then I think, don't you think that we should call the records of that case?
that also can be done.
That is the only way out to
Of-
file
of
whether you
course,
have filed an
yes.
appeal, because they will have an order
Yes,
by the deputy commissioner, you decide.
they will have an order. This order copy also has not been furnished to me. I make it in my plane. It's very clear. And this copy also was made available to me through my cousins. And for that there was a delay also. This order has been passed way back in 2022. And after that also the DB court has never furnished me the copy of this DB court order.
I have heard the learned counsel appear, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and so-and-so, the learned counsel appearing on behalf of the respondents. The case of the petitioner herein, in brief, is that the DBO heck has no jurisdiction to decide or sit over an appeal over the decision of the village council, upper and middle Kohima system. On the other hand, the learned counsel appearing on behalf of the respondent submits that there is no mention anything that the petitioner herein had approached this deputy commissioner in terms with Rule 31 of the rules of administration of justice and police in Nagaland 1937. Taking into account the above, this court is of the opinion that the records of Miss/Civil/case number 102/2022 pending before the court, before the district customary court, Nagaland, it called for would throw light on the present litigation. Accordingly, this directs the registry of this court to call for the records of Miss/Civil/Case number 102/2022 from the court of the District Customary Court, Head, Nagaland. List the matter again on 29th of July 2024. In the meantime, the registry shall do the needful so that on the next day, the records are placed before this court.
Oblige your lordship.
For hearing item numbers 23 to 33.
May I please, your lordship? I beg to mention item number 25, my lord. The main counsel appearing for respondent, private respondent 5 to 87 could not turn on today due to his ill health. He's on leave.
Who is he?
Takakichu. His name is not reflected in court list though, but he has filed an affidavit. So your lordship may kindly be pleased to list this particular item for Friday for hearing.
No, lordship.
May it be Thursday?
How can it be done on Friday? I can't delete this matter.
May it be Thursday, my lord? May it be
Lordship,
Thursday, my lord?
No.
May it be Thursday, my lord?
they have already filed their affidavit in reply. So, opposition.
Lordship, I have similar prayer for 2728 and 29, your lordship. Since my senior is out of station, your lordship, if this particular
Players
matter can be
were
heard on
not
Thursday, your
present
lordship.
on the last occasion when the matter was called.
Lordship,
Present.
they are present, your lordship.
Then didn't they know that the matter was taken up finally today?
Lordship,
My lord, it is. But it's just because of an ill health he couldn't turn on,
Huh?
my lord. It is, he knows that. Just because of an ill health issue, he couldn't turn on, my lord.
Health issue, what had happened?
He's on leave as well.
Huh?
He's on leave. He had an health
No,
issue.
he knew about this thing.
Right.
What is the health issue?
I am not well aware of his health
Then
issue, but
take it as a statement being made, a false statement being made before this court.
no, my
You
lord.
can't come up with like this. Why shouldn't we initiate contempt proceedings against him for making a false statement before this court? You can't take this court for a ride like this. It's a very difficult thing. I practiced on that side also for 24 years. So, don't worry. You have not appeared. You are there now. Your name, you have signed the Wakalatama. Fantastic. Take that ground in the appeal. If I am dismissing, you are allowing his petitions. If I am dismissing, then very well you should be happy. Or then she can take a ground that the respondent was not given an opportunity. Don't worry. Yes, Mr. Javi.
Lordship, the matter was heard on 6th, and today is the date fixed. And in fact, I've been given opportunity to obtain instructions. And Lordship, I have sought for written instruction as regards the recruitment, how a recruitment was done. Now, your lordship, regarding advertisement, no advertisement made. That is one. Lordship may kindly come to that order. 3 orders is there.
Then how did the people know that there was that we are to participate in the selection?
Lordship. Just short submission, 10 minutes only, your lordship, I'll make your lordship. Your lordship is right. In matter relating to public employment, your lordship, that has to be done by way of an advertisement, your lordship. Now, in fact, even in the state now, with the constitution of the NSSB, your lordship, all posts now is by way of advertisement, either through NPSC or through NSSB, depending on the nature and the category of post, your lordship. Now, the post in question in district petitions is in respect of constable, your lordship. Now, constable, that category falls under NSSB.
And
NSSB, Nagaland Staff Selection Board. The other day, your lordship, I have given that regulation, NSSB regulation, it must be in the file, your lordship.
yeah, it falls under
NSSB, Nagaland Staff Selection Board.
NSS
SB,
SSB.
NSSB.
Nagaland
Staff Selection Board. Now,
yes.
no, your lordship, the other day I have given that regulation, NSSB regulation, your lordship. Now, may I take your lordship to page 107 of the regulation?
Of
107 of the regulation. The other day I placed that NSS 107. This is the handwritten pagination. 107. Running page is 341. 107 lordship has got it. This is Schedule A, your lordship.
Yes.
Now, Schedule A, posts which are exempted from the purview of NSSB. Actually, the post of constable should come here. But your lordship may kindly see the
But Mr. Zameen, this came in 2022.
lordship.
20.
July 2020, after the appointment were made. But why I'm referring to this, your lordship, is this is relevant to appreciate the issue involved in this, your lordship. Now, below the table, your lordship, the recruitment to the post of constable, your lordship, fire constable, warder, female warder, placed in the Department of Police, prison, Nagaland local, Nagaland Police Telecommunication Organization, Home Guard and Civil Defense, fire and emergency, your lordship. All these posts are exempted from the purview of NSSB, your lordship. Now, if your lordship may kindly see, all the posts which are exempted from the purview of NSSB, your lordship, all these posts relates to maintenance of law and order, your lordship, and emergency services, your lordship. Now, in other words, those posts relating to maintenance of law and order and then emergency services, your lordship, like these are exempted. Taking into
Nagaland Lokaयुक्त.
Nagaland Lokaita, I don't know how it came, but it came. So that maybe Lokaita has been given the jurisdiction, some extra discretion, your lordship. Now, exempted in the sense that like it cannot be done through the regular recruitment process. Supposing emergency, like law and order situation is there, additional manpower is required. Now,
If for temporary purpose.
if for that.
Now,
but
you may appoint them till a regular appointment is made.
yes, that is.
But no rights to follow upon them. You say that all these appointments will go. This is only temporary and this won't remain. Nothing is there. We are going to have an advertisement in respect to all these things and appoint. Yes, for immediate requirement you can. But can you put a stamp of authority on such appointment that, okay, this is being done?
Lordship, your lordship is right. But your lordship may also appreciate that, like, so far as appointment of constable is concerned, your lordship, it is governed by the Nagaland Police Manual. And Rule 20, your lordship may see in the Rule 20 that authority is given to the.
When was this police manual made?
Your lordship.
When was the police manual made?
No. This is notified, your lordship. I have given in my affidavit in opposition.
Now, when was it made? This police
This is
manual?
2016 actually. This is notified in 2010.
Police manual.
Police manual, in my affidavit, page 13. This is gazette notification. In my affidavit in opposition, Your Worship, this is 2010.
Do they have a post of police manual constables?
Yes, Your Lord.
Where is it?
Like here in Rule 20.
Rule?
Rule 20. I have flagged, Your Worship, the last one, last flag. The third flag. Rule 20, this is enlistment of constable, Your Lordship. So number one, superintendent of police will make all appointments of constable. After appointment, the constable will be sent to police training school for basic training course.
But it does not say.
No, the rest are all eligible.
No, but it does not say the procedure.
Correct, Your Worship.
So if the procedure is not there, then
Correct.
we will think that the procedure is meant to be in consonance with Article 14.
Your Lordship, but here, now though SP has been given the authority, Your Lordship, the Home Department has come out with those orders. The first order is the 5th September, which I have given to Your Lordship. Lordship, yeah. Now, the 5th September order, may I read out?
Similar, the excess appointment of Ziman in the Suyan is hereby that all the unit command not to make any appointment without specific approval of the committee to be considered by PSU. All requests and application being received by the unit commander shall be forwarded on receipt of such application in Iman upon receipt of the selected list from the DGP Iman, the unit commander.
Upon receipt, selected whatever DGP, the unit commander may appoint those personal. Though SP is the appointing authority, he cannot at his own whims and fancy, Your Lordship. So by this order issued by the Home Department, how it is to be done. Now, next order is 3rd December 2018, Your Lordship. Prior to this, there was a ban, but by this order, subject relaxation was done, relaxation on appointment. Second para. It is further directed that DGP may constitute a committee under the chairmanship of an IGP to scrutinize the application for appointment of police constable and NCE received from various units and individuals, and approval for appointment shall be conveyed by PHQ on the basis of recommendation made by the committee to respective commanders, Your Lordship.
So here
Now,
it
the
says
third order,
when these appointments were made
between 2018 to 2020.
after December 2018.
Yes, after in the maybe 2018 to that exact. I don't know, Your
No,
Lordship.
because here one thing very relevant of this 3rd December.
Yes.
It is further directed that the DGP may constitute a committee under the chairmanship of an IGP to scrutinize the applications for appointment of police constables and NC received from various units and individuals, and approval for appointment shall be conveyed by the PHQ on the basis of recommendation made by the committee to the respective commanders.
Yeah.
So meaning thereby, so if appointments were made earlier, at that time if there was a ban or freeze. Well, you see, the ban or freeze was removed
on
3rd of December.
On 3rd of September.
3rd of December.
No.
No, kindly see
Why?
the document
No,
you have given.
No, right, 11/1/2018.
What?
The third line. I am directed to state that the ban freeze imposed on appointment such and such, that is memorandum such and such.
No. See the 3rd December 2018 document.
But issued by 5th September 2018.
Maybe
The last line.
Yeah, the government has decided to lift the present ban freeze for appointment of so and so. So
Right.
only on 3rd of December.
No, 5th September 2018, the last line of that first paragraph.
The appointment for those shall be carried out only after clear vacancies should be in accordance with the order issued. No. Here it is for the first time said that the government has decided to lift the ban freeze for appointment. So if that be so, so there was a ban at that point of time, how did you appoint?
No, the exact, I don't remember the date, I can't say the date, but they are appointed in between 2018 to 2020.
So it must
But
have been
Lordship-
prior to that,
Okay.
there was a ban.
Now, maybe that, okay, that portion, that period, that can be segregated.
Okay,
Now, your
then
lordship,
after this,
now coming to this, yes, lordship, coming the next notification by the PHQ. So
Yeah.
in terms of the direction issued by the Home Department, your lordship, the DGP has considered the committee. And based on this recommendation of the committee, your lordship, the appointment will be made.
Appointment of so and man. Scrutiny of the committee will put up the recommendation on each application in on receipt of the previous remand, the union commander will make the appointment against clear vacancies.
so you
But-
had clear vacancies.
Yes, your lordship.
So
my-
many. How many appointments are there?
Maybe prior because of the ban, your lordship.
Understood. How many was vacancies were available?
Here, 935.
935.
35. Yes, Lordship, and the clarification here is,
So there were 935 clear vacancies.
there are others also. The next writ petition arising out of this in continuation is 2 other writ petitions.
How
That
many
was,
petitions? No, entire
that
batch
was
of
in
it.
other 2 writ petition not listed
Oh,
today.
those which have been
Yes, Lordship
segregated.
has
That is,
already
that is
given-
inspector, sub-inspector.
Sub-inspector as well as exclusive constables, those whose appointment orders were not provided by the department and concealed. So the second RTI, they gave those another connected writ petition that was subsequent provided.
No, understood. So here we are only concerned with constables.
Yes, that's why.
So those constables, how many posts are there?
935, yes.
935.
In another one, 186.
Which one?
The
No,
other one
again,
is
madam, kindly don't come there.
Lordship.
Let us not get confused. I mean, anyways, confused today with a lot of matter. Yes.
And also one clarification, Lordship. The appointment here we have annexed is January 2018 to September 2019. Appointments only.
All appointments,
All appointments in between January 18 to
2019.
September to 2019. Only in this writ petition. In this writ petition, 189.
What about the others?
Others also varying in between.
No, you have to therefore give me a clear idea. Do you mean to say that if this court is going to search, I'm going to dictate in the court? Don't expect that I'm going to make it CAV. I don't have the habits of CAV business.
And this is before COVID. There is no question of COVID in 2018-19 Lordship.
You never know. Nagaland may have.
No.
That was pre-COVID.
No.
Pre-COVID.
I hope the state does not make the center embarrassed with this statement that this was during COVID period in 2018. Because the center maintains the stand that it is only in March 2020 COVID came to India.
And Nagaland afterwards, even afterwards.
Okay. So here is a case of 7th of December 2018 following the 3rd of December 2018.
No, sure.
Because at that point of time, there was a ban.
There was a ban.
The ban was removed on 3rd of December 2018, unless you have any
Yes,
other document to
yes.
show that there was a lifting of ban earlier to that.
Yeah, no, going by this order, your lordship.
This showed that the ban was only on 3rd of the,
Yeah,
and therefore they constituted a committee on 7th.
On 7th, your lordship.
Okay, now, Mr. Jami, only one thing. How will they assess the applications, maybe whatever urgency, without, from whom?
Now, your lordship, as per the first notification, first order dated 5th September, your lordship.
Which one?
Now, the first order, 5th September 2018.
Yes.
Second para. all the requests and application which are received by the unit commander, that is in the respective unit, shall be forwarded to the PSU on monthly basis.
Where?
The second paragraph,
In order to streamline the excess employee.
the second para, or the third para, all the requests and application
Being received by the
unit
unit commander shall be forwarded to PSQ on monthly basis.
indicating the number of vacancies in the, in other words, your lordship, earlier unit commander used to make appointment, and that is how those access appointees, your lordship. So by this not order, your lordship.
So you mean to say that earlier also there was never an advertisement?
No,
No,
Yes. Like going by this, your lordship.
it seems.
Going by this,
So
because
whoever wants and goes and files an application, they can do so in the PHU.
the unit commander, SP, your lordship.
So there must be therefore somewhere mentioned that the unit commander has a right to receive the application.
No, because going.
Somewhere.
No, prior to this manual, like 20, as per this manual, your lordship, the appointing authority is the commander, your lordship. SP, commandant, their equivalent rank.
Now, understood. So unit commander can he do so without anything?
That is what they were doing. So that is why
No,
the
so
government has
therefore-
come out with this.
No, very well, but show me that the unit commander receives application.
No, Since
From
he,
this-
no, since he is the appointing authority, your lordship, perhaps because of that, application was put up before him for appointment, your lordship. And that is how the unit commandant, he used to appoint driver, cook, constable in the rank, whatever. So, and then that led to excess appointment. So that is why the ban, there was a freeze in appointment. And the government has come out with this order, not the unit commander, whatever we application received, that has to be forwarded to the PSQ on monthly basis.
Understood.
Yeah.
But how does the unit commander receive? There must be some procedure. You can't receive, the unit commander cannot receive an application unless there is a procedure stipulated.
But that was how, as going by this, that is how it was practiced.
That can't be there. If that be so, these appointments will be illegal. Understood. If they are mentioned somewhere that unit commanders shall receive applications and thereupon they will proceed. But there has to be some power or some entrustment, some procedure in any proceedings where there is no procedure. It smells of Article 14 violation, arbitrariness, everything, writ large.
I have understood your lordship, your lordship.
So my judgment becomes too small.
But just my submission, your lordship, is also. this.
Understood. The problem arises there. Without an advertisement, without any procedure, if these appointments are made. Understood. If we are saying that, okay, we are not going to. This is only, if you are saying that you are doing for some exigency. Yes, you can make very well some temporary appointments till proper selection proceedings are initiated. That is another aspect. But can you say that for exigencies, we give any appointments, not for law is not required. And one fine morning, you remove the ban, and you are to therefore say that these 9, it is you who have put the ban. You have removed the ban on 5th of December, and therefore it is therefore required to say out there that there was a necessity of urgent need. And as such, kindly go ahead. Where is it? It seems to be an afterthought. It gives me an indication of this Govardhanji Bhansi's case,
No,
1952 Supreme Court.
All this comment, no, this is not so, your lordship.
I am not saying any truth. This
No.
yes.
No.
On the face of it, you say that on account of exigencies, we are doing it. Very well. Urgentness, yes. Then why did you have a ban at the first place? If you had, so you required these people.
The freeze was bad, the ban was because of the excess of.
Understood. If there is an excess appointment, why you don't need the ban? If there is an excess appointment, you don't need people. Both of them has to go together.
No, till this excess, maybe by then, by the time it was relaxation, by then perhaps the excess appointment, those were adjusted. And that is why, okay, it has been, the ban was removed, Your Lordship.
But where is it in 512 stated that there is an urgency required for appointment?
No, Your Lordship, here, Your Lordship may kindly take also into consideration the fact that there are also appointments which were made in the midst of COVID pandemic, Your Lordship.
COVID is not there.
No, in 2020, Your Lordship.
No, the appointment is
They-
only in between 2000,
the-
mostly August, prior to August 2019.
Mm.
No, there is
So-
no COVID at all. That cannot be misleading.
No, I think by August 2019, we were in COVID time.
No, 20,
Oh.
March 20,
March 20.
15th of March 20.
But 2020, if I'm not mistaken, I think the
This
appointments
is
are.
why
in
I'm
between-
saying,
No.
should the state government embarrass the central government? Because they have maintained that we got the COVID
Yeah.
from China.
2020. Okay. Okay, 2020 it is there, but then, yeah. But this, my submission, Your Lordship, is this. Admitted, I admit,
Lordship,
no advertisement was made, Your Lordship. But
And there is also no procedure stipulated in any rules that the unit commander can receive.
yes, but
Is that your stand also?
yes, but the fact of the matter is that there were application before the PHQ. And a committee has been constituted. And based on the.
No, maybe I may file an application before some pawn shop. Tomorrow, can you say that, oh, he give it out there, we are appointing? No. Or I may give an application to her. Giving her is okay, you can appoint anybody.
No, application has to be as produced through the unit commander.
Where is it? Show me that provision that it has to go through unit commander, where is it? If that is not there, if the unit commander has no power to receive the application, how can he process it?
exactly.
That is the question. Once there is a freeze. In fact, your government should be happy if I interfere.
Your Lordship, no, not just on the ground that there was no advertisement, Your Lordship. Because if that be the ground, all appointment has to be irrespective of exigency in service, because these are all like they are used for like maintenance of law and order, emergency service, Your Lordship.
Emergency service, you take it, do whatever need. If you have emergency, but law and in the name of law and order, on one hand, you freeze it. On the day when you lift the freeze, you don't say that there is a requirement of urgent thing, but we want to regularize these excess appointments. And thereafter, you say that you are going to put it, all these PHQ things will go through this selection process, these people will look into it. And now you say, whatever may be emergency service. That is why I'm saying 1952 Commissioner of Police versus Govardhan.
Exactly. I have the citations.
Atal 1952 is the,
Exactly, Lordship.
or the best was the words of Justice Krishna, I think, in the case of Mohinder Singh Gill, paragraph 8. Orders of the public authorities are not like old wine which ages with the time.
Lordship, there is one history. In Nagaland Police Department Constable recruitment, 206 posts were advertised, where on the other hand, they were appointing through backdoor. They advertised page 101 B1. They advertised 206 posts on August 2019 in the midst of the appointment. But this is different. But I just want to show, if they can advertise 206 constable posts, at the same time, on the other hand, they have appointed more than thousands without advertising. And it is never administrative exigency, because this is the adopted system in the police department, that there is no advertisement at all. in police department. And this is the only advertisement placed before this honorable court. And my lord, in your wisdom knows.
Where, in the affidavit, they have put an
No,
advertisement?
in my
But in
writ
the
petition,
writ
lordship.
petition, in the writ.
101, page 101. So this has to be cleaned, lordship. This backdoor, menace of backdoor has to go.
This is in August 2019.
Yes, they advertise, this is the advertisement.
Invited for male or female from here by the district director of so-and-so belonging to any Naga tribe, including recruitment is consistent of. Chalo. Yes, what now the screening committee is different, no? IPS.
So your lordship,
And-
based on what?
So how many petitions, which are the persons who have been, how many selections you have challenged?
Writ petitions,
Why you are challenging selectively means you are challenging all appointments.
all appointments, lord. This
And
is the
just
short,
for example, on 3rd of January 2018,
yes, lordship.
respondent number 6 was appointed.
Yes, lordship.
So all these appointments are given differently.
Different day, on the same day. The appointment orders itself is very fishy, lordship. They will appoint,
Show me one of them. Having been declared medically fit by the medical board of India, who was born is hereby appointed in the existing vacancy of the unit with effect from 10/4/2018 in the scale of play plus other so and so. Appointment is terminable within 1 month's notice from either side and also subject to verification of character and antecedents.
21st April. Just in a year, consistently every month.
And here it does not say anything about selection.
No selection at all, lordship.
Why?
All,
Where is the mention about selection? Selection board?
Your lordship may kindly see 190, writ petition 190.
189? 189, kindly see page 59.
189 on the recommendation.
Where? In a page 59, 189,
Page,
writ petition.
page 59.
18.
No, page 59, that is different. This is what? Your lordship may kindly see page 66.
And this is a cook. He is appointed as cook. The cook is urgently
No,
required.
this is second half, please give.
Yeah, otherwise without cook, the unit people will starve. Your lordship may see page 66.
66.
66. 67,
They,
the recommendation. So,
Page
66, 66, 67, 68, 69. It's a different, this thing, order.
no, they are all appointed on 2nd July. Only those appointed on 2nd July, it is mentioned on the recommendation of PHQ
71,
from 66 to 70.
page 72, on the recommendation of PHQ, 74, 75.
There is no government approval.
The order, the wordings are different, your lordship. But only the fact of the matter is that, your lordship, no advertisement that I concede. But then some.
Here in this item, 53 posts have been filled up.
Yes, lordship.
Now,
This is,
is it in all matters, different persons have been challenged?
yes, all the 995, 35, no, 35, lordship.
No, 95 is okay, but are you challenging in each writ petition?
Yes, lordship. And
It-
this
it
is,
is just, for example, in 189, are you challenging A? And 190, you are again challenging A.
no, another. This is according to battalion wise. All over the district, battalion wise. We have filed this. with the-
Battalion wise.
Yes, battalion wise. So here in 189, it is NAPTC. This is Chumukidima, the training center. First NAP Mahila. These are the Chumukidima is first NAP.
You do me a favor, you
Lordship.
take it up again on Thursday and
Lord-
dictate it in the court.
Lordship.
You give me a list out there, means In which writ petition?
I have already, Lordship. We have prepared. That
In
one.
which writ petition, which case, means the annexures which are there, which requires to be interfered.
Oh,
Which battalion?
these are the battalions, Lordship. Whether this will be sufficient or not.
Kohima, 189, Nagaland Police Center, 13 posts. 13 posts, you have to give me those annexures. Because you see, one has to identify. I can't say 13 posts. What 13 posts?
Of constables.
Understood.
Yes,
Where?
Lordship.
Those particular annexures. Get the point? Then it becomes easier. Otherwise, I have to find out, and I don't have the habit, no CAB business. Now, tell me, without advertisement, why appointment cannot be made on exigency purpose?
It's not a question of exigency, Lordship. It's a practice.
Okay,
Let
let
us
understand the state government people want these people to be appointed. They like their faces.
Because it is opposed to constitutional schemes, as your Lordship.
Show
in
me
your wisdom.
something that Supreme Court has said something.
Of course, Lordship. Besides Supreme Court law of the land, Lordship, since 1976, I have annexed in my petition since 1976. Office memorandum has been issued and I have also brought some, but here is page 97, annexure C. This is the office memorandum issued by the state government, 1976.
Your Lordship, I think that Lordship need not go into that because affidavit, in my affidavit, I let us notify OM I have annexed, Your Lordship, 2016, which has been superseded, Your Lordship. So Your Lordship need not go into that.
I have others.
What did you enclose?
In my affidavit in opposition, Your Lordship.
Yes. Where?
No idea.
Oh, this one, 7th of December 2016.
16.
This is procedure for grade 3 and grade 4 posts. Are these constables in grade 3 or grade 4?
As per the latest ROP rules, it comes under Group C
Group
and
C.
Group D.
Group C, that
Group
will be
C.
under this thing. Actually, Group C post should be
Are they
under.
grade 3 or grade 4?
No,
Some are grade 3, some are grade 4.
Because one thing you have done all these things out there, just your office, all these posts, just for example, that compassionate appointment, you have put it as Group C, Group D.
This is
You go for that assured
MSCP.
MSCP, again Group C, Group D.
Earlier it was grade, we use it grade 3, grade 4, now with new ROP. and
Now
all
here
that,
it is again, you are having the grade 3, grade 4.
Yeah, generally, all
are
of them, they
spooks.
come. Now, Your Lordship has got my affidavit in opposition,
Yes, yes.
page 14, para 2. Para 2, the last line, except police department.
Including vacancies shall be filled on recommendation and all.
So,
shall be
1976 OM may not be reliable.
on the maybe.
I'm just trying to impress my lord that since 1976, ban without inviting application is enforced. But they are just,
But anyways, you are going to fill up by direct recruitment, you can do very well. There's no problem with that. You have a selection process, it's very well. But how will the people know?
that is the issue here, Lordship.
If the people doesn't know, how do you have it?
I mean,
Yes,
I
yes,
am here.
Where is Supreme Court saying it?
I am here whether this floor.
And how many are the petitioners?
Petitioners are
And all the petitions, these are different petitioners?
same.
So how many are the petitioners? Are we having 952?
No, Lordship.
Otherwise, wouldn't it be a case of public interest litigation?
26 petitioners. The first one is 2014-13 SCC, Lordship. Lordship, Uma Devi's case that even layman knows Uma Devi's name and I may not. Lordship, I will just, Uma Devi's case also I have, but
In the principal seat for the last 3 months, I am taking up civil matters, so I don't know.
Uma De citations.
Yesterday, Mr. Jamil, I was reading a very beautiful judgment on the difference between promissory estoppel and legitimate
2014,
expectation.
13.
Lordship had time to read those judgments.
Yeah, no, I keep on reading. So it's a beautiful judgment of our Chief Justice of India. I think it's 2023 10 SCC. I forgot the name. It brings a beautiful concept like in England, you have a concept of promissory estoppel.
Hmm.
You have the concept of legitimate expectation. But in England, promissory estoppel is not a cause of action. See, it can be used as a shield, not a sword.
As a defense.
It can be only used as a shield, not a sword. Therefore, in England, they use the legitimate expectation on the basis of the principles we involve or evolved as promissory estoppel. So they put that if a government or anybody comes up with some representation and a person concerned or on the basis of which a person changes,
Act on it.
Changes, he may not because it's a shield. He cannot take any action. He can't file his case under promissory estoppel. On the ground of unfairness, he can have a cause of action on the basis of legitimate expectation. Thereafter, Justice P.N. Bhagavati, in the case of Motilal Padampat, says in India, taking into account the cue from the judgment of the Chief Justice of, I think, in Australian Supreme Court of the Australian, he observed that in India, we have made the concept of promissory estoppel sword. And as such, a cause of action would be there. And therefore, there is another judgment in 2012 4 SCC where Justice Gokhale differentiates what is promissory estoppel, what is legitimate expectation. He said if it is a case of legitimate, a person may not be entitled to in terms of the promissory estoppel, but he may be entitled on the basis of a legitimate expectation. Just for example, an industrial policy comes out wherein it has been mentioned that we are going to give you sales tax exemption.
Tax exemption.
That's a policy of the government. But to implement it, you need notifications. But a notification has not been issued. So can you, on the basis of promissory estoppel, get it? No.
Legitimate expectation.
On the basis of legitimate expectation, you ask for a mandamus to get that notification. This is the very recent development, but in case of Motilal Padampat, the Supreme Court said that on the basis of promissory estoppel itself, therefore there is always a confusion. So therefore this judgment of Justice Chandrachud beautifully says what is the difference between these two, how it is to be acted. In 2023 10 SCC, you just find out the name, you get the judgment. Promissory estoppel and legitimate. Beautiful judgment. Yes, what is this?
Yes, Lordship, this is pertaining to a constable who was appointed without advertisement and served 15 years was terminated. Now, Lordship, the operative portion is starting from 7 to 13. Page 2014 SCC, 13 SCC, page 232, Lordship.
You are referring to paragraph number?
Paragraph
11.
7, 8,
11.
9, 10, 11, and 13. I may be allowed to read out, Lordship, or,
Unnecessary.
oh, Lordship. After 13 years, the appointment, constable appointment was
2014,
13 SCC,
13 SCC, 292, 232.
232,
Para,
page
eh, लिख लो,
232, para 7 to 13.
7 to 13.
Yes, Lordship.
Then
This is one. 2007, 8 SCC, 264.
which one? We got there?
2007, 8 SCC, 264. A sum up of important laws in matters of public appointments. 8 principles laid down to be followed. Twenty-four. 23 is also there, Lordship, but 8 principle. The first one, regarding this one, the first one,
Where? Para?
para 24, para 24. 23 is also, 23 and 24, 23 is also relevant, Lordship. 24 lays down in matters of public appointments, the following principles are to be followed. So 8 principles lay down. Our case relates to
You are concerned with 24-1.
24-1 and 3
What is there?
and
3?
4.
Why you are
To-
bringing 3?
And 3
An appointment made in
violation of the mandatory provisions of the statute.
Where? Which statute?
Oh, it's not 3, Lordship. It's previously used.
Let us
4,
go.
4,
24-1.
1 and 4.
4, what is it?
Those who come
By back.
by back door should go through back door.
1 and 4.
Yes. One
Yeah.
is the appointment made without following the appropriate procedure under the rules, government circulars, and without advertisement or inviting application from the open market would amount to breach of Article 14 and 16 of the Constitution of India.
So 24-8 also comes in?
That also, here no selection process, but yet it is also relevant.
No,
Lordship.
no. Kindly see.
When
The entire.
entire
state-
selection is stinking, conceived in fraud and delivered in deceit, individual innocent has no place and the entire selection has to be set aside. Here, no selection, so it has to be, entire appointment has to be set
So we
aside.
need not hear 5-87 of that item number 5 or something.
Lordship,
Somebody was asking for an adjournment.
Lordship.
So we need not hear it
Yes,
in
yes.
view of 24.
That, on the other hand, Lordship, exactly, Lordship.
Okay. Then
Individual innocence has no place, Lordship. The law is very clear. Then 2006, 2 SCC. 482, page 482.
don't repeat the same. The Supreme Court has the right to say, I may have delivered many judgments, I may be
Lordship.
repeating the same.
Here, at least 21 is very relevant because in there,
Umar
if
Devi.
it- yes,
Okay,
Lordship,
2006 4 SCC. page
21,
Yes.
para 21. They have neither pleaded nor
21
is
case.
there any material to show that the appointment of respondent number 1 has been made after issuing public advertisement.
Where, para?
21, Lordship.
21 in Dharwad's case. That is what has been mentioned.
This is UPSC versus Girish Jayantilal Vaghela.
No, you are referring to Umar Devi.
2006 2 SCC.
No, this is 4 SCC. Okay,
Oh,
come
2
to Umar
SCC.
Devi. Umar Devi, what you want to show?
Uma Devi is paragraph 25, 26, 38, 43, and 47,
Let
Lordship.
us go by 25. This 4 then concludes the normal role of the human.
courts will be made to release such a document. How is it relevant? 25 has no relevancy.
A little bit that,
Let us not go
It's-
others have more relevant. Then
it's mainly to do with, regularization, Lordship. However,
where
26,
26 has no relevance.
then 38.
38.
Yes, Lordship. Then 43, though it is mostly,
This is again UPSC, this one, 22.
And-
2006 to SEC, you have already casted so
Lordship.
unnecessary.
Nevertheless, since this is the basis of, backdoor appointment, we cannot overlook this aspect, that's why it
Humanity,
is.
how is it relevant? Hello, not necessary humanity, out. Yes.
Then 2006
To humanity out there.
to SCC,
This is the one, paragraph 26 in Umar Devi.
and this is
Para,
21, Lordship. None of the respondent has pleaded that. It is neither pleaded nor is there any material to show that the appointment of respondent number 1 has been made after issuing public advertisement or the body authorized under the relevant rules governing the condition of service of drugs inspectors in the Union Territory of Daman and Diu and had selected him.
so
Yeah.
what is, Mr. Jami, what is the present selection procedure of this constable? You have taken it out of NSSB.
Yes, Lordship.
What are you
No.
doing now?
No, as per this thing, the manual, your Lordship, in Rule 20, some criteria have been given. How?
No, but understood, that is criteria is being given, which will be the benchmark for selection.
Lordship.
There's no quarrel with that. But what is the procedure still now?
Actually,
Nothing.
Lordship, some rules has to be there. Rules has to be
There's
there.
no rules. You may have a criteria. The manner of selection is the criterion may be very much there. But for the purpose of selection, that cannot be under any
At
circumstance.
least some guidelines should be there.
Right
There
now,
are-
executive instructions, something needs to be there. As of now also you don't have.
Agree, Your Lordship.
Lordship, in 2006, 24 is also relevant, 21 and 24.
Para 21 and 24.
Yes, 24 says, for the reasons discussed above, we are clearly of the opinion that respondent 1 cannot be said to be a government servant as he was working on contract basis and therefore he was not eligible for any relaxation in upper age limit. The view taken by the High
How
Court
is
is
the upper age limit relevant here?
that
No.
Lordship, so 21 is relevant.
It is
And my lord will kindly appreciate,
2006 to SCC, page 482, paragraph 20.
yes, then,
And anything more?
yes, Lordship.
Yes.
This is 2014, 14 SCC 50.
What does it say?
Lordship, para 8, starting from 8. This has covered the whole aspect of, this law has covered the whole aspect, all the important judgment of the Honorable Supreme Court has been cited. Here I have just referred to 8, para 8.
Okay, 2014, 14 SSC 50.
Para 8,
8.
9. Whether I should read out or just give the
Not
paragraphs,
necessary.
Lordship.
This is non-sponsoring of name by them. However, due to possibility of non-sponsoring, the court held that any appointment, even on temporary without inviting application, is in violation. This is 12. 12 is 96. Did you show? No. It's okay.
9,
8 and 9 and
10, 11, 17. In fact, all the paragraphs are
Did the
paragraphs.
court sum up anything? There it is, para 16. We are referring to all other things. Come to para 16.
Sixteen.
16.
Yes, Lordship.
Another important requirement of public appointment is that of transparency. Therefore, the advertisement must specify the number of posts available for selection and recruitment. The qualification and other eligibility criteria for such posts should be explicitly provided, and the schedule of recruitment process should be published with certainty and clarity. The advertisement should also specify the rules under which the selection is to be made, and in absence of the rules, the procedure under which the selection is likely to be undertaken. This is necessary to prevent arbitrariness and to avoid the change of criteria of selection after the so-and-so. Thus, the aforesaid decisions are an authority in prescribing the limitations while appointing. So, para 15, 16, and 17.
Yes, Lordship. In fact, all the paragraphs are very relevant, Lordship. This has covered the whole issue of backdoor appointment.
Sure. I think this is enough for this. Anything? Yes, Mr. Jamil, any judgment that without advertisement appointments are legal?
I considered, Your Lordship. I consider, but the only thing is that.
No, show me anything where the High Court should not interfere, even without an advertisement.
My only submission is this, Your Lordship. Now, I admit, no advertisement was made, but has some process.
How do I take care of these judgments?
Procedure has been.
No,
followed,
but
Your
Mr.
Lordship.
Jamil, how do I take care of these judgments? Give me a good idea. You are such a senior counsel. Give me an idea. How do I take care of these judgments? Okay, I'll not take it from your mouth that you have considered. Let us take him.
Lordship, I have three other citations also, but.
No. Yes, anybody wants to say that, how could I take care of these judgments? Yes, Mr. Longshire.
One of as your lordship has pointed out, is it the public interest litigation? That is a very pertinent issue.
Which one?
As your lordship has pointed out, that we have not made out a case that here your right happened violated. Number one. Before I started going into the issue, I want to make one point clear. The writ petitioner never filed Talapan. So the petitioners, respondents, they are totally in the dark. Who? The respondents.
Who is in that?
Because none of the respondents have been served with the writ petition.
You have not got it?
No. What is the role of our High Court?
How did you go for publication?
No. The state government council was provided all the care of through DGP. And we provided all the writ petition to the through DGP.
And the court passed an order?
Yes, Lordship.
So
That is long
if
time
your
back and
DGP,
now
your
just coming.
employer does not give you the copy, then it is your lookout.
My lord, I don't think the copy will furnish.
No, that is not our responsibility. We have already followed the orders of the
So
court.
they have duly given the copy to the DGP.
Yes.
That is for the official respondent, my lord.
Anyways, tell me,
Yes.
whatever may be, how do you take care of without advertisement?
Malo,
Give me, here also a very senior counsel, give me one idea, how do I take care of these judgments?
Malo, there present respondents, private respondents, whom I am representing. They've applied. Approval was given from the HQ. And you were appointed. In first, one issue is that NEP is a different establishment that is armed police. SP is executive for the IR is Indian Reserve Battalion. All of them they are made as a party respondent in the writ petition number 199. So I'm saying that SP is a independent establishment.
No, kindly come to the point. Other points are not relevant. How an advertisement can be protected, how an appointment can be protected in view of the law laid down by the Supreme Court, that any without a public appointment being made in absence of an advertisement or requisition from the employment exchange would be violation of Article 14 and 16. I am asking you, show me anything where an exception can be created in types of jobs where you have been appointed.
My Lord, lead counsel for the government have already replied to that. I don't want to.
No, I want only that. Kindly don't come up with all these things. These technicalities I'll take care of it. Don't worry. In my judgment. Only thing, answer me this specific query. How is it possible? And here the jobs are less, 952. The Calcutta High Court has already struck down 22,000. Similar
teachers. But one fact remains that the present private is he applied.
When did
for
you
the
appear?
job.
No, when did you appear, Mr. Longsha? Before the court?
My Lord, if I'm not mistaken, I appeared on 18/3 of 2020.
20?
18/3 of 2024, if I'm not mistaken. Because on that day, I filed this.
What is this?
Preliminary objection.
Now, this is an affidavit.
Yes. And there was no decision on this. Anyway.
When did you file the wakalatnama?
Must be along with this. So what happened is that when I filed it, I was furnished with a copy of the writ petition.
Then,
He has
in
already filed
which matter
affidavit.
you were appearing?
199, my lord.
199.
You are only appearing in 199.
199.
Yes. 199. Coming, 199. You are representing for everybody.
Yes, in 199.
Now, why did you accept receiving only one copy?
No, I
Why
was,
did your deponent say
yes,
to file the affidavit that I have understood the contents of the petition? Why did the deponent say that he has understood the contents? And your deponent also says that he has the authority to file the affidavit on behalf of everybody. How? And you are the sole counsel. You may not have asked for 100 copies. That's your lookout.
my lord. But
So
it,
that,
it isn't there.
no, Mr.
What
Longsha,
I'm-
that submission
What
was
I'm
not
submitting
workable.
is under Gauhati High Court rules.
High Court rules, don't worry.
Yes,
This court will take care. High Court rules cannot override Article 14. Yes.
my lord,
Anything else?
yes.
Yes.
As my, the fact remains that the petition, the private respondents, they have completed their training. All along the petitioner, they were waiting. After completion of their training, only the petitioner woke up
No.
and approached this scope.
Anyways, it's a writ of quo warrant.
My lord,
Don't worry.
I understand.
Limitation is not there.
So
It's a public job.
my submission is under the High Court rules, which have not been complied with. That is clear from the record.
But your affidavit also makes it very clear that that deponent has due authority to file the affidavit in opposition for everybody. And the deponent have understood the contents of the affidavit,
My lord,
the petition.
yes.
Then what remains?
Please that part be reflected. That is para one. Your lordship has said it.
And it is pursuant to your affidavit in opposition which filed earlier. Thereafter you filed it. And there was an order being passed by me on 19th saying that let all these parties, whoever
Exactly.
is appearing,
Yes,
shall
yes,
file their individual pleadings if you file your affidavit thereafter.
Exactly.
And therefore I fixed the matter for hearing in the month of February and fixing it on 19/3.
Exactly, Lordship.
And you filed it on 18/3.
And it was published 4 times in the paper in 14th October 2022. Even that was also done. Even after nearly 2 years, they
Yes,
did not
anybody
appear.
else who wants to make submission?
Your Lordship, I am appearing for the respondents in 192. 192. Everything has been discussed. There is no judgment in the entire corpus of the precedents regarding selection without due process. But only one aspect, Your Lordship, I would like Your Lordship to consider with regard to the petitioners, respondents.
we were rightly or wrongly, we have been selected and then appointed. And then we have also undergone the training, Lordship. That aspect of the matter. That is a different thing. That is a different thing. Only thing, how do I take care of these decisions? I'm asking you, as learned counsels, help me out so that I can help you and retain your appointment. Is it possible? Your Lordship, we cannot submit more than what has already been submitted by the. In fact, there is one judgment which could have helped was the police appointment made in Assam which went to the Supreme Court. There, the Supreme Court interfered with the judgment passed. Initially, it was passed by Justice Gogoi. There's a single bench where entire scrutiny was made by the High Court. Then the matter went to the division bench affirmed it and also made another scrutiny out there. Total scrutiny was there. In the Supreme Court, when it went, a plea was taken that a certified copy was asked for the order, the copy. And that was not given, which Mr. Longsir makes. But this is being taken care of here by an order passed by this court whereby copy was given and the deponent saying that I have due authority to file the affidavit for everybody and also to the defense. Under such circumstances, the only way out it is. Mr. Jamil, I'm fixing it on Thursday, 2 o'clock. I'll dictate the court in the court itself. You just find out only one thing. Can the state come up with a plea that the state is going to go for a recruitment? Until then, there may be, because there will be further, once I set aside, tomorrow the state may also take realization from them. Nowadays, the states are very dangerous.
Lordship, just one clarification, Lordship.
Yeah.
This matter pertains to 2019-2020 1-year recruitment only. There is yearly recruitment. This constable pertains to only 1-year recruitment, one tenure. Now what has happened is even before they could take training or whatever selection, we approached this honorable court for stay of taking recruitment. And they were not allowed to take training in Chumukidima, that is the NAPTC, where all recruitments are conducted. So it was not allowed by the tribal bodies within the jurisdiction of Chumukidima NAPTC, under the jurisdiction of Naga Tribal Union. Because they were against the backdoor appointment, and until and unless the posts are advertised, we will not allow the backdoor appointees to be recruited. So we approached this honorable court for stay of their training. However, this honorable court was of the opinion that file for bring their appointment plus before this honorable court, then we will quash it. That was it. That's why we have to withdraw this first writ petition, that they gave only data without giving us the appointment order, though appointment order was filed under RTI. They did not provide.
Madam, I'm in your favor.
No.
Now I'm
Just
really
a-
helping, asking how can,
Lordship.
you see, after all, whatever may be, law is one thing, justice is another.
Lordship.
The question
Exactly.
is, how can, if there is any way to save, that is why I'm asking them, how do I save their appointments? Yes, you appoint this man, that is the law. Now, how do I
Exactly.
take care of the justice? These people with 952 will be removed from the service. Is it any matter that the state comes up that yes, we are going to go for a selection?
Yes, Lordship.
And all these persons will also be taken into account. They can deliver and participate. And they will be given some, whatever additional sum for some work, they may be given for the 2 years, they may be given some age relaxation or some bonus point to that effect. If some decision comes out to that, then their things is protected until, and the state will come up with a particular stand that we are going to have this selection within a particular period of time. And in the meantime, till then they can remain. I see this will be a justice to these people, so that then the court, the state will also recognize. And your thing is, yes, there was no advertisement. Yes, this is the requirement of advertisement. So there will be an advertisement.
Yes.
But they will be also given some additional benefits of age relaxation will be there. There will be a case that they have rendered 2 years of service. Training is there. So the state, when they have a training, states in public exchequer money is also involved. So for that, they may be given some concession or some marks for that, something to that effect if the state comes up with that. Which is then I think the justice would be served.
Thursday, Your Lordship.
Just get to that. Because then I think, you see, otherwise to save them is impossible. Only thing is, if it is the state stand to that effect that yes, we are going to go ahead with this.
Yes.
And in that process, if we are going to go, we'll be doing the new selection or AI within 6 months or 7 months. In the meantime, this AI will remain only till that period. And thereupon, they will go for this year and these persons shall be within this lordship. And they will be given some age relaxation here. Then I think the purpose of them also, they have been, because another thing is tomorrow the state may very well, if that stand is not given, the state may very well take, oh, these are illegal, kindly give me back my salary. Where will they go? What do you think, Mr. Longchair? You are the one who huh?
Noah's Ark for me.
I think this is the only way something can be done. Otherwise, it will go something, them also, they are there, they have maintained their family, however maybe. And you also know, I also know how jobs you get it. If it is a backdoor, there is something. So something can be done for them that these 2 years, all these things is relaxation if these things comes up. It's the matter again on Thursday at 2 p.m. Lordship.
Oh, blush.
Lordship, we may be allowed to submit the.
Oh, please submit. This will be required because I have to dictate the judgment. And if Mr. Jami, if there is anything, put it by way of an affidavit, a short affidavit, your state.
Lordship.
If it is possible, if something can be worked out.
Lordship.
Or if necessary, if you come up with this, then I will have the matter, take the matter also and hear it through video conferencing also. You can finish it out. If the time, further time is required for that. But this is the only way, otherwise to.
Deeply obliged.
Lordship, I may bring for the correspondent 197 and 198. Lordship, I may be allowed to make my submission on first still.
No, you can make still. How do you protect?
I think
I've been asking you for the first time. You have been asking everybody to come out.
Deeply obliged.
it's all the same.
No, so that this is the only thing I'm making it clear. Can you in any manner distinguish these judgments?
This lordship is rightly pointed out. Most of the respondents, they are overage now.
Huh?
They are overage.
Oh, that is why.
That's why age relaxation will be given.
The council, what I'm saying for them, that let the state come up with a policy that we are going to give an age relaxation to those who have been working for this period. Have been appointed. Yes, there was a fault of the state. May not be 2 years, but if that is being given, some justice is done to you also. That is what I'm saying.
Deeply obliged.
Obliged, Lordship.
I cannot get it.